Trump vs. Barbara. Dissenting opinion of Justice Thomas, joined by Justice Gorsuch. This court's decision in Dred Scott vs. Sanford would have permanently denied citizenship to blacks as a subordinate and inferior class. After the Civil War, the Reconstruction Congress overruled Dred Scott, first with the Civil Rights Act of 1866, then with the Citizenship Clause of the 14th Amendment. Both the Civil Rights Act and the Citizenship Clause guaranteed citizenship to persons born and domiciled in the United States regardless of their race. Neither guaranteed citizenship to persons who were not domiciled in the United States. Blacks were entitled to citizenship because they were Americans. They had no other homeland, owed no allegiance to any foreign power, and were subject to no other authority. They fought and bled in the same battles, gained and gloried in the same victories, and were liable to be called upon to defend America in time of war, alongside every other citizen. The Citizenship Clause thus guaranteed them the dignity and glory of American citizenship, so as to ensure that they would never be treated as second class under the law. The same could not be said for the children of foreign temporary visitors. Foreign temporary visitors were attached to their home country, lacked similar bonds to this country, and would not be called upon in time of war. Americans, consistent with their settler ethos, believed that citizens were the people who called a place home. Accordingly, domicile, a person's legal home, played a key role in both state and national citizenship in America. A person was a citizen of the state where he had his domicile. When foreigners temporarily visited, their national character was unchanged. Such visitors were strangers, not subjects. A person born here but domiciled in a foreign land was therefore considered as much a stranger to the country as his father. That is why, when Dred Scott went to court, he argued that to be a citizen, it is only necessary that he should have acquired a domicile. After this court held that Scott was not a citizen because he was black, Republicans in Congress, such as Representative John Bingham, stated that a person was a citizen if he was born and domiciled in the United States. Scott was a citizen, in their view, because he was born to Americans, not to temporary sojourners. As Frederick Douglass had put it, the freedmen sought citizenship, not as aliens nor as exiles, but as Americans. Congress implemented the principle that citizenship follows birth and domicile in the Civil Rights Act of 1866 and then in the Citizenship Clause of the 14th Amendment. The Civil Rights Act guaranteed citizenship to persons who were both born in the United States and, as relevant here, not subject to any foreign power. The phrase, "not subject to any foreign power," excluded from citizenship children of foreign temporary visitors, who were subject to the power of their home nation. The Citizenship Clause, which the same Congress passed shortly after the Civil Rights Act, was understood to have the same meaning. It guaranteed citizenship to persons who were both born in the United States and subject to the jurisdiction thereof. A person was subject to the jurisdiction of the government of his domicile. Domicile was the foundation of jurisdiction over persons. The government of a person's domicile had broad power over that person, including with respect to his personal affairs, his conduct abroad, his personal taxes, and the mutual duties of protection and allegiance. So, as the senator who introduced the Citizenship Clause explained, the word jurisdiction, as here employed, ought to be construed so as to imply a full and complete jurisdiction, the same jurisdiction in extent and quality as applies to every citizen of the United States now. After all, Congress would have no right to make citizens of persons temporarily resident. The Citizenship Clause was consistently interpreted not to apply to the children of foreign temporary visitors, who were by definition not domiciled in the United States. Regardless of administration or party, the federal government for decades after ratification regularly denied claims to citizenship by children who were born in the United States but not domiciled here. When a child was born in the United States to parents domiciled abroad, he was not, therefore, under the statute and the Constitution a citizen of the United States by birth. Letter from Section of State Bayard to Winchester, in Wharton, Digest of International Law 399-400. Scholars agreed, a child born within the territory of the United States, of alien parents, was not a citizen unless his parents were permanently domiciled within the United States. Robinson, Notes on Elementary Law 70. This court agreed, the Citizenship Clause excluded from its operation children of citizens or subjects of foreign states born within the United States. And Congress agreed, the Citizenship Clause did not extend to a child born here but subject to any foreign power. See Enforcement Act of 1870. As Justice Harlan would write in his dissent in Plessy v. Ferguson, the Citizenship Clause gave citizenship to all born or naturalized in the United States and residing here. The court offers a different account. American citizenship, the court says, was based on a medieval English feudal principle, according to which each person owed personal service to the lord of the soil as his master, a perpetual servitude that was born with the child and only ended in the grave. Americans, the court says, adopted this feudal principle as a rule of American citizenship with little fanfare. Then, according to the court, the Reconstruction Congress codified that feudal principle with the words, not subject to any foreign power, in the Civil Rights Act and, subject to the jurisdiction thereof, in the Citizenship Clause. Then, the court says, the clause's meaning was definitively settled by dicta in United States v. Wong Kim Ark. With due respect, the court's account is not historically accurate. The court says that the Citizenship Clause incorporated the English feudal principle that subjects owed lifetime servitude to the king who owned the soil on which they were born, but Americans, unsurprisingly, rejected this feudal principle. The court's theory of American citizenship is based on the opinion of a New York assistant vice-chancellor in an inheritance dispute called Lynch v. Clark. But, the assistant vice-chancellor's reasoning, whatever it was worth, was not even followed in New York by the time of the Citizenship Clause. Finally, the court reasons that dicta in Wong Kim Ark settled the meaning of the clause. But, Wong Kim Ark itself emphasized that its holding was limited to persons domiciled in the United States. And, scholars and government officials continue to agree after Wong Kim Ark that the Citizenship Clause did not extend to the children of foreign temporary visitors. The rule remained what it always was, a child born on American soil of a stranger or traveler passing through the country, or temporarily residing here, was not a citizen. Black, Handbook of American Constitutional Law 634. The court today takes the extraordinary step of holding facially unconstitutional the President's order excluding from citizenship the children of foreign temporary visitors and illegal aliens. In doing so, the court adds to the sad history of the 14th Amendment, which was designed and understood to secure equal rights for the freed blacks but has instead been repurposed for political projects that the Reconstruction Congress did not support. Because many potential applications of the President's order are consistent with the original public meaning of the Citizenship Clause, I respectfully dissent. I begin with early American practices related to citizenship and nationality, which inform what the Citizenship Clause means. In America, you were generally a citizen if you were born here and this was your home. The legal word for home was domicile. The concepts were so linked as to be taken as effectively synonymous at times, such that Justice Bushrod Washington could say, citizenship means domicile, home, permanent residence. The same correspondence has persisted throughout American history. Harding v. Standard Oil Company, domicile and citizenship are substantially synonymous terms, in most cases. Citizens were not the people who were temporarily passing through a territory or who happened to be born within it. Citizens were the permanent members of the body politic, the people whose roots were in a place, who called that place home, and who would, if necessary, go to war for that place. The law of both state and national citizenship reflected this principle. Domicile was critical for state citizenship. As Chief Justice Marshall explained, a person was a citizen of that state in which he has a fixed and permanent domicile. Eberly v. Moore, citizens, if domiciled, Barber, citizenship, by domicile, Story on Constitution, change of citizenship, by change of domicile. Temporary visitors, it followed, were not citizens. When a person went to a new state on a mere temporary visit, for a transient purpose, Justice Story explained, he could not thereby claim to be a citizen of such state. Instead, to become a citizen of the state to which he removes, someone had to show that he had his domicile there. Catlett v. Pacific Insurance Company. The same rule remains in place today. As a general matter, an individual is deemed a citizen of the state of his domicile. Domicile was also critical for national citizenship. As this court stated the rule, when a person acquires a domicile in a nation, he becomes a member of the new society, at least as a permanent inhabitant. Domicile played a role in determining someone's national character, which would change whenever he removes to a foreign country and settles himself there, with an intention permanently to reside there. He was a subject of the nation where he was domiciled. He followed the character of that country, in war as well as in peace, e.g. Halleck, Elements of International Law and Laws of War 144, explaining that, in war, national character turns on domicile, Hanger v. Abbott. Thus, the view of the executive branch was that when a person acquires an American domicile, the law enjoins upon other nations to respect him, in regard to protection, as an American citizen. Letter from Section of State Marcy to Hulsmann, in correspondence between the Secretary of State and the charged affair of Austria relative to the case of Martin Costa 18. See also Report of the Committee on Foreign Affairs concerning the rights of American citizens in foreign states, App. 100. Domicile confers a national character. It does not allow anyone who has a domicile to decline the national character thus conferred. Costa 18. His status remains as long as the domicile is retained, and is changed with it, see also. This approach was consistent with this country's settler ethos. Daniel Webster wrote that, no government has carried the general presumption further, than the United States that a person attains a new, national character, when he settles, and intends permanently to reside, in a nation. Report of Secretary of State Webster. Although some nations would lay claim to anyone born in their land or any descendant of their citizens, America viewed its people as the people who built their lives here. A person domiciled here pays the same price for his protection as native-born or naturalized citizens pay for theirs. In war he shares equally with them in the calamities which may befall the country, his services may be required for its defense, and his life may be periled and sacrificed in maintaining its rights and vindicating its honor. Costa 20. E.g. the Dos Hermanos, reasoning that, if upon his return to New Orleans, he acquired a domicile there, he became a reintegrated American citizen, the Mary and Susan, N.F., discussing the effect of domicile upon national character. The United States thus did not claim as a citizen every child born on its soil. Instead, pursuant to the principle that children followed their parents' domicile, a child was a citizen of the place where his parents were domiciled. A child born of foreign parents is not, on principles of natural reason, necessarily to be considered as a citizen of the country where he is born. If he was born in the country, but both his parents were strangers not designing a permanent change of country, then he was as much a stranger to the country as his father. The rule was that, when a subject is traveling or sojourning abroad, he continues under the protection of his home nation, so his children are an exception to the rule which makes the place of birth the test of citizenship. Ludlam v. Ludlam. See also, for citizenship to be acquired by birth, a child must be born to parents belonging to no other nation or tribe. Hardy v. de Leon, a child born on American soil to parents domiciled in the then Republic of Texas was a citizen of Texas. Political Code of New York. Citizenship requires domicile and excludes children of transient aliens. The relationship between citizenship and domicile was a matter of general law from which the political branches could depart by statute, but those statutes also typically tracked the domicile rule. So, Congress retained the prerogative to set the terms for becoming a naturalized citizen and could impose requirements beyond domicile. See Art. I, CL 4. But, when Congress enacted naturalization statutes, they too generally tracked the domicile requirement. Act of March 26, 1790, -104, requiring 2 years of residence for naturalization, requiring 5 years of residence for naturalization. And, even when a person was domiciled here and not formally naturalized, he was already considered a citizen for some purposes. Before being naturalized, domiciliaries were de facto though not de jure citizens of the country of their domicile, or domiciled citizens, Costa 20. Likewise, for other purposes, national citizenship was not an independent concept but simply derivative of state citizenship. Every citizen of a state, it was often said, was ipso facto a citizen of the United States. In these contexts, too, national citizenship required domicile because state citizenship required domicile. Of course, birthplace closely correlated with domicile. Most children were born where their parents were domiciled and where, as a result, they were domiciled. The correlation was especially strong in the early 19th century, when crossing an ocean for a temporary visit was an unappealing prospect for pregnant women. Because birthplace was often a heuristic for domicile, it could be generally stated that children were citizens of their place of birth. But, when the specific question arose, a reasonable qualification to that general statement accepted children of parents, who were in itinere in the country, or abiding there for temporary purposes. Story, Commentaries on the Conflict of Laws 48, Story on Conflict of Laws. The law of domicile is essential to understanding the citizenship provisions of the Civil Rights Act and the 14th Amendment, so I briefly explain the relevant parts of the law of domicile here. Domicile meant legal home. The most common definition of domicile was residence with the intent to permanently remain. The Venus story on conflict of laws, residence, and the intention of making it the home of the party. A person's residence was the place where he lived. Philomore, The Law of Domicile 16-18, Law of Domicile. He had the intent to permanently remain in that place if he planned to stay there indefinitely. A person was not domiciled in a place simply because he was temporarily present or born there. A person's presence in a place was merely, prima facie, evidence that he was domiciled there. Story on Conflict of Laws 45. Because a person's temporary visit to a place did not change his domicile, persons who were temporarily present in a place were regarded by the law not as subjects, but as strangers. Accordingly, a person's place of birth was only prima facie evidence of domicile. Overseers of Reddington versus Overseers of Tewkesbury L. 289, the place of the birth of a legitimate child is prima facie the place of his settlement. A child took on the domicile of his parents. Because any person incapable of establishing his own domicile had the domicile of that person, on whom he depends for support, it followed that generally, minor children had the settlement of their fathers. So, if a child was born to foreigners who did not permanently reside here, the child was not domiciled here. See Law of Domicile 69 Dicey and More, Digest of the Law of England 103, Dicey and More. Finally, each person had one and only one domicile. Every person must have a domicile somewhere, and every person can have only one domicile. Inhabitants of Abington versus Inhabitants of Bridgewater Field, Outlines of an International Code 147. The supposition that a man can have two domiciles would lead to the absurdest consequences. Inhabitants of Abington. A person can reside and intend to permanently remain in only one place at a time. And, no person according to the law of nations is without a domicile. Field 147. So, if someone did not intend to remain where he was at the moment, the law ascribed that person his last such place as his domicile. Because a person could have only one domicile, domicile was a natural criterion for citizenship. In the 19th century, dual citizenship was considered highly undesirable, if not a contradiction in terms. The general view was that no one can have two countries. Mensel, Jurisdiction in 19th-century international law and its meaning in the Citizenship Clause of the 14th Amendment, 32 St. Louis Pub Rev. 329, 334. Dual citizenship led to a number of foreign policy concerns, such as conflicting claims on the dual citizen during a war. Report of 1868 Inhabitants of Abington. Therefore, the United States did not recognize a double allegiance. Representative instead, under our law, a citizen was bound to be true and faithful alone to our government. Savorgnan versus United States, the United States has long recognized the general undesirability of dual allegiances. Because each person had one and only one domicile, domicile-based citizenship avoided the problems attendant to dual citizenship. The principle that citizenship followed domicile also made it more likely that citizens would be attached to their country. As Alexander Hamilton envisioned it, the citizenry were the people who would join together against any threat, a large body of citizens, who stand ready to defend their own rights and those of their fellow citizens. The Federalist No. 29, see also Report of 1868. As Frederick Douglass saw it, citizenship belonged to those who fought and bled in the same battles, and gained and gloried in the same victories. And, as this court put it, it is to the citizen that the country must look for its safety. United States v. Gettysburg Electric Company. The dignity and glory of American citizenship, Plessy, belongs to people who have a meaningful tie to this country, Tuan On Nguyen v. INS. A domiciliary had, by definition, the sort of permanent attachment to a place that befitted him to citizenship. Law of Domicile 17 Costa 20. A temporary visitor whose homeland was somewhere else, although he had legal rights and was entitled to dignified treatment, lacked the ties to this country that would make him fit for citizenship. He therefore was generally not eligible for naturalization, and his children were likewise not naturally citizens of their birthplace. Once a person became domiciled in a place, he was considered no longer subject to any foreign power. A person was subject to the government of where he was domiciled. When a person traveled abroad, he remained subject to the power of his home nation, much like an American who travels abroad today remains subject to the power of this government. As this court explained, if a person goes into a foreign country on a temporary visit, he remains subject to the power of his home country. When a person moved to a country permanently, by contrast, he was no longer subject to the power of the country from which he originated. Those who resided in a new nation from a permanent cause became subject to the new nation. See also Schooner Charming Betsy at 992. American legal authorities described a person as subject to the jurisdiction of the government of his domicile. Then, as now, governments exercise different types of authority over temporary visitors and permanent residents. A government does not apply the same laws in all matters to persons who are only temporarily resident, as it applies to persons who are permanently resident within its territory. So, while a government applied, among other things, its ordinary criminal laws to temporary visitors, it had a wide range of further powers only with respect to persons domiciled within it. For that reason, when someone was present in a territory but had a domicile elsewhere, although he was still amenable to the laws of the host government, that government would describe him as not subject to our jurisdiction. In contrast, when a party made his habitual and usual domicile in a place, he became, in 1860 parlance, subject to the jurisdiction thereof. A person was subject to the jurisdiction of the government of his domicile because of the legal relationships that followed from domicile. The fact of domicile was one of the highest importance to a person. Inhabitants of Abington. It was said that domicile determines a person's civil and political rights and privileges, duties and obligations. It fixes his allegiance. It determines his belligerent and neutral character in time of war. It regulates his personal and social relations, whilst he lives, and it furnishes the rule for the disposal of his property when he dies. The legal relationships that followed from domicile, which collectively made a person subject to the jurisdiction of the government of his domicile, could be grouped into four categories. First, domicile determined which government had the power to declare the law as to an individual's most important personal affairs. Story on Conflict of Laws 51-52. The law governing personal affairs included the laws of marriage and divorce, which followed a couple's domicile. E.g., it included laws governing the succession of a person's estate, which was distributed, according to the law of distribution of the place of his domicile. And it included laws governing a person's age of majority, his capacity to contract, his right to sue, and his rights with respect to movable property. Inhabitants of Abington Dissent, for jurisdiction over these personal affairs had exclusive operation given to it only with respect to persons domiciled. Mere territorial presence was not enough. Wharton Treatise 1872, Wheaton, Elements of International Law 140-142. Second, domicile determined which government had plenary jurisdiction over a person to regulate his actions anywhere. The law governing domiciliaries, unlike the law governing temporary visitors, had effect given to it beyond the limits of the territory, see also, e.g. And, as now, a government could exercise personal jurisdiction over domiciliaries while the domiciliaries were abroad and for their conduct abroad. Cid. In personam judgment has extraterritorial force, when rendered by government where domiciled, e.g. id. Third, domicile determined which government had the power to impose personal taxes on a person. The power to impose personal and income taxes depended on the party's domicile. A sovereign could tax the property in its territory belonging to anyone, but it could impose personal taxes, such as a capitation tax, only on persons domiciled within it. A person not domiciled is not within the jurisdiction of the assessors. He was not liable to taxation in the city for his poll, income and personal property, because his residence and domicile was not in the city. In Re Hood's estate, describing the rule of great antiquity and of high obligation, that taxation follows the domicile. So, while transient travelers were not liable for ordinary governmental or municipal taxes, such taxes could be collected from domiciled aliens. A non-domiciliary could recover taxes as improperly collected because he was, regardless of his territorial presence, not subject to the jurisdiction of the taxing authority. Fourth, domicile determined which government owed a person protection when he went abroad. As this court explained, the American citizen who goes into a foreign country, although he owes a local and temporary allegiance to that country, is yet, if he performs no other act changing his condition, entitled to the protection of our government. So, before the Civil War, the federal government intervened to protect Americans abroad based on their domicile. Costa 8-27. A non-naturalized domiciliary abroad was entitled to protection as an American citizen. The Department of State throughout the 19th century repeatedly confirmed the right of persons domiciled in the United States, but not naturalized therein, to maintain internationally their status of domicile, and to claim protection from this government in the maintenance of such status. This protection abroad corresponded to the primary allegiance that the domiciliary owed his home government. When a person went abroad for a time, his own state still possessed a right to his allegiance. Hall, The Foreign Powers and Jurisdiction of the British Crown 1-2. He continued under the obligations of his home allegiance, and his children, though born in a foreign country, were not born under foreign allegiance. Although he owed a partial and temporary allegiance to his host nation, he was excused from military service and other obligations distinctively associated with natural allegiance, because he owed a prior and more binding allegiance to his own sovereign. Domicile was for that reason typically a prerequisite to, among other things, compulsory service in the militia. See Halleck, International Law 385 at 991 Swearer, interpreting the Citizenship Clause within the context of contemporaneous political debates on alien conscription and expatriation A&ML, and Civ, Government 73, 86, 95-96. And, although America more than other nations supported the right to change that allegiance, it held that doing so required a change of domicile. When Dred Scott sued for his freedom, he claimed to be a citizen of Missouri, the state of his domicile. Scott, a black man held in slavery, sued in a federal court, which could hear the case only if it was between citizens of different states. Scott argued that he was a citizen of Missouri and that the defendant, Sanford, was a citizen of New York. Scott, though, was not born in Missouri. He was born in Virginia but domiciled in Missouri. See Fehrenbacher, the Dred Scott case, its significance in American law and politics 240 tr. of record in Dred Scott v. Sanford. He alleged that he was a Missouri citizen because he and his family were brought there in 1838, where they have ever since resided. He argued that the term citizen described persons identified with the communities where they reside. Brief for Dred Scott 5-6. In response to the argument that blacks could not vote and therefore were not citizens, Scott explained that a person need not have acquired all these rights, it is only necessary that he should have acquired a domicile to enable him to sue as a citizen. Citizenship, Scott argued, in terms that would have been familiar at the time, means nothing but residence. Nobody disagreed with the premise that Scott was domiciled in Missouri. Black slaves and freedmen alike were unambiguously Americans. They were not foreigners at 1160. They were not aliens. They owed no foreign allegiance. It was the dissimilarity of American blacks to foreigners that Frederick Douglass emphasized in his call for recognizing the citizenship of blacks. We address you not as aliens nor as exiles, humbly asking to be permitted to dwell among you in peace. Instead, we are Americans. So, speaking the same language and being of the same religion, worshiping the same God, owing our redemption to the same Savior, and learning our duties from the same Bible, Douglass reasoned, we shall not be treated as barbarians. American blacks were liable to perform all the duties and support all the obligations of citizens, at 1117. They were domiciled in the United States, whether in slavery or freedom. Law of Domicile 45 brief for Dred Scott 6 at 1160. Dred Scott was therefore a citizen of Missouri. This court disagreed. It held that Scott was not a citizen of Missouri, and therefore could not sue as a citizen, because of his race. According to the court, blacks could not be citizens because they were considered as a subordinate and inferior class of beings, who had been subjugated by the dominant race, and, whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who held the power and the government might choose to grant them. As a result, the court said, blacks were denied the basic privileges of citizenship, including the right to keep and carry arms wherever they went and to exercise the full liberty of speech in public and in private. They could not sue in federal court as state citizens. Justices McLean and Curtis dissented. Justice McLean would have ruled that Scott was a citizen of Missouri because he had a permanent domicile in the state. As he stated the law of citizenship, being a freeman, and having his domicile in a state different from that of the defendant, he is a citizen. Likewise, Justice Curtis took the position, common at the time, that national citizenship was simply based on state citizenship. He said that birthplace alone is not sufficient to be a national citizen, but that a person must be both born here and a citizen of a state. Those persons born within the several states, who are citizens of the state, are thereby citizens of the United States. State citizenship, of course, was based on domicile. Justice Curtis thus agreed that Scott was a citizen of Missouri. Critics of the Dred Scott decision consistently took the position that citizenship should be based on birth and domicile regardless of race. Domicile, after all, was colorblind. In the words of Representative John Bingham of Ohio, soon to become a central figure in the crafting of the 14th Amendment, all free persons born and domiciled within the jurisdiction of the United States are citizens of the United States from birth, at 983. Blacks such as Dred Scott called America home, so they were citizens despite having been subordinated based on their race. As Representative Schellebarger would explain, persons of African descent whose ancestors were slaves, were entitled to citizenship, because they were domiciled in our own country and continued here to reside at 1160. Likewise, Representative Philemon Bliss condemned Dred Scott and explained that all persons born here were citizens regardless of their race, except for children born to temporary sojourners, at 210. Chief among the critics of Dred Scott was Abraham Lincoln. Soon after the court released the decision, Lincoln declared that the Dred Scott decision is erroneous, and did obvious violence to the plain unmistakable language of the Declaration of Independence. The case exacerbated national division over the issue of slavery and contributed to Lincoln's election as president. Lincoln vowed not to acquiesce in it as a precedent, but instead to do what we can to have it overruled. During the Civil War, Union officials continued to define citizenship based on birth and domicile. Lincoln's Attorney General Edward Bates wrote that the place of birth was prima facie evidence of citizenship, a rule that corresponded with the familiar rule that place of birth was prima facie evidence of domicile. President and Fellows of Harvard College see also, every citizen of the United States is a citizen of the particular state in which he is domiciled. The Lincoln administration deemed persons citizens if they were born and domiciled in the United States. C. Mrs. Preto was born in New Jersey, and, no doubt, at her father's domicile, so she was, therefore, born a citizen of the United States. Congress's discussion of who could be subject to a wartime conscription law focused on the distinction between temporary sojourners and those who settled here with the intention of making their home here. Only the latter were fully and completely subject to the law at 992. For the purposes of conscription, children of foreigners born here were American citizens, if permanently domiciled in the S, and could avoid conscription if their parents had not established a long-term residence in the United States. Even at a memorial service for Lincoln, prominent statesman George Bancroft confirmed that every one born on American soil, with the few exceptions of the children of travelers and transient residents, owes it a primary allegiance. Honorable Bancroft's oration at the obsequies of Abraham Lincoln, the pulpit and rostrum, Numbers 34 and 35. After the Civil War, Congress vindicated Lincoln's vow to overrule Dred Scott, first with the Civil Rights Act, then with the Citizenship Clause of the 14th Amendment. Congress enacted the Civil Rights Act of 1866 to repudiate Dred Scott. The Civil Rights Act of 1866 confirmed that former slaves were citizens, but it did not extend citizenship to foreign temporary visitors or Indians who were still within their tribes. The Civil Rights Act guaranteed citizenship only to persons born here and not subject to any foreign power. In full, the citizenship provision of the Civil Rights Act, which formed the basis for the Citizenship Clause at issue in this case, stated that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. Temporary visitors domiciled in a foreign country remain subject to a foreign power. The Civil Rights Act therefore intentionally excluded children of foreign temporary visitors. The congressional debates were clarifying on this score. When Senator Trumbull introduced the Civil Rights Act citizenship provision, he stated that the language excluded persons temporarily resident in the United States, whom we would have no right to make citizens, at 572. He had considered limiting the Civil Rights Act citizenship provision to persons owing allegiance to the United States, but he abandoned that terminology because temporary visitors owed a partial allegiance to the United States, and he wanted to make clear that the Act excluded them. Likewise, when Representative James Wilson spoke in support of the Act in the House, he explained that every person born in the United States is a natural-born citizen, except, it may be, children born on our soil to temporary sojourners. Others confirmed that the Civil Rights Act excluded the children of temporary visitors. Representative Bingham described the Civil Rights Act as simply declaratory of pre-existing law, ID. Which, he had already explained, required that a citizen be both born and domiciled in the United States. Bingham understood the Act to grant citizenship only to children of parents not owing allegiance to any foreign sovereignty at 1291. Representative Martin Thayer agreed that the Act required that a person not owe allegiance to a foreign power. Of course, temporary visitors and their children owed allegiance to their home country. Unsurprisingly, then, the public interpreted the Act to guarantee citizenship to all persons born in the United States, except those subject to foreign governments, a class which included those born to foreign parents temporarily sojourning in this country. The Chicago Republican, March 30, 1866, see also Lash, Prima Facie Citizenship, 101 Notre Dame Rev 101, 147. The Civil Rights Act also excluded from citizenship Indians not taxed. This provision was intended to exclude Indians and tribes, but to recognize the citizenship of Indians who had left those tribes and joined the body politic. In Senator Trumbull's words, it excluded Indians who belonged to the Indian tribes. See at 572. But it included Indians who were no longer connected with their tribes and instead lived and earned a livelihood in the white settlements. Tribal Indians were considered virtually as foreigners, but whenever they were separated from those tribes and came within the jurisdiction of the United States so as to be counted, they were citizens of the United States. Like temporary visitors, tribal Indians were not completely subject to the jurisdiction of the United States. The United States did not have the right to impose personal taxes on them, hence, Indians not taxed. Their personal affairs remained subject to the jurisdiction of their tribal nation. The right of self-government was secured to each tribe, with jurisdiction over all persons and property within its limits, subject to certain exceptions founded on principles somewhat analogous to the international laws among civilized nations. Republic No. 474, 23d Cong. First Session. The United States did not interfere with the disposition, or descent, or tenure of their property, as between themselves, or prove their wills, or subject them to the laws of marriage and divorce, or subject them to the laws of the United States, against high treason. Tribal Indians did not owe the United States primary allegiance and did not receive from it complete protection. See Ibid Cooley, General Principles of Constitutional Law 243 Elk ID. Republic No. 474. See also Tenant, excluding Indians not taxed, Dred Scott, Standing Bear, Elk and the legal status of Native Americans in the latter half of the 19th century, 86 International SOC Sci. Rev. 24, 29. Native Americans were comparable to foreigners because they did not fall completely under S jurisdiction. Indians and tribes were not covered by the Civil Rights Act's exclusion of persons subject to any foreign power, because Indian tribes were not foreign. They were domestic dependent nations. Thus, to preserve the status quo that tribal Indians were not citizens, Congress used the clause, not subject to any foreign power, excluding Indians not taxed. Although the Civil Rights Act by its terms overruled Dred Scott, the Reconstruction Congress could not be sure that it would endure. Some questioned whether Congress had the constitutional power to enact the Civil Rights Act and thus feared that a hostile court might neuter it. Others worried that, as soon as the Democrats came into power, they would repeal the act. Flack, the adoption of the 14th Amendment 95 Foner, the second founding. Thus, when it passed the Civil Rights Act, the Reconstruction Congress was already drafting the 14th Amendment. C.I.D. Lash, The Origins of the Privileges or Immunities Clause, Part 2. 2 months later, Congress would formally propose the Citizenship Clause of the 14th Amendment to the states. The states ratified the amendment in 1868. The Citizenship Clause of the 14th Amendment constitutionalized the Civil Rights Act's citizenship provision. The main object of the clause was to settle the citizenship of freed slaves. In full, the Citizenship Clause provided: all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. This language, all agreed, unambiguously overruled this court's contrary holding in Dred Scott v. Sanford, that the Constitution did not recognize black Americans as citizens of the United States or their own state. The Citizenship Clause forever closed the door on Dred Scott and constitutionalized the Civil Rights Act of 1866 by foreclosing a racial criterion for citizenship. Velo Madero, quoting Lash, The 14th Amendment and the Privileges and Immunities of American Citizenship 171, see also Slaughterhouse Cases ID. The Citizenship Clause did not change the Civil Rights Act's rule. The clause and the act were passed by the same Congress during the same session. Senator Howard, who proposed the Citizenship Clause, believed that it hardly warranted discussion because Congress had just enacted the same rule in the Civil Rights Act. The Senate had so fully discussed the question of citizenship as not to need any further elucidation at 2890. He also stated that the Citizenship Clause is simply declaratory of what I regard as the law of the land already. Senator Trumbull, who had introduced the Civil Rights Act citizenship provision, confirmed that the object to be arrived at is the same. Senator Johnson had no doubt that all that this amendment provides is that all persons born in the United States and not subject to some foreign power are citizens of the United States. To be a citizen, Senator Howard said, meant to be not a subject of a foreign power. The phrase, subject to the jurisdiction, was a familiar way to describe the relation of a domiciliary to his home nation. Lawyers in America would have known that a person was subject to the jurisdiction of the place of his domicile. Congressman confirmed that the clause should not be construed to refer to the bare territorial power that a sovereign exercises over all persons in its territory. I understand the words here, subject to the jurisdiction of the United States, Senator George Williams said, to mean fully and completely subject to the jurisdiction of the United States at 2897. The word jurisdiction, as here employed, Senator Howard explained, ought to be construed so as to imply a full and complete jurisdiction, the same jurisdiction in extent and quality as applies to every citizen of the United States now. The Citizenship Clause, Senator Trumbull agreed, means subject to the complete jurisdiction thereof. So, although, in one sense, all persons born within the geographical limits of the United States are subject to the jurisdiction of the United States, Senator Williams explained, some were not covered by the Citizenship Clause because they are not subject to the jurisdiction of the United States in every sense. Each of these descriptions precluded applying the Citizenship Clause to the children of temporary visitors, who, unlike children domiciled here, were not subject to the jurisdiction of the United States in every sense. It was on this basis that Congressmen believed that the clause fixed in place the rule of the Civil Rights Act. Senator Trumbull stated that the Citizenship Clause, like the Civil Rights Act, would still exclude all persons subject to a foreign power. What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means. Senator Howard agreed that the Citizenship Clause would not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States. And, shortly before the Citizenship Clause was introduced, Senator William Fessenden, a supporter of the amendment, explained that persons may be born in the United States and not be citizens of the United States, then gave the example of a person who is born here of parents from abroad temporarily in this country. See Lash, 101 Notre Dame Rev. The Citizenship Clause, just like the Civil Rights Act, also excluded from citizenship the children of tribal Indians, meaning Indians whose tribes retain sovereign authority over them. Certainly, Senator Howard said, gentlemen cannot contend that an Indian belonging to a tribe, although born within the limits of a state, is subject to this full and complete jurisdiction at 2895. As Senator Trumbull saw it, tribal Indians were excluded because they, like temporary visitors, retained a primary allegiance to, and therefore were subject to, their tribal nation. It cannot be said of any Indian who owes allegiance, partial allegiance if you please, to some other government that he is subject to the jurisdiction of the United States. He concluded, it is only those persons who come completely within our jurisdiction, who are subject to our laws, that we think of making citizens. Congress was satisfied that its language accomplished that result with the phrase, subject to the jurisdiction thereof. As Senator Williams explained, I would not agree to this proposed constitutional amendment if I supposed it made Indians not taxed citizens of the United States. But I am satisfied that, giving to the amendment a fair and reasonable construction, it does not. The Citizenship Clause used different wording from the Civil Rights Act only to resolve an uncertainty that had arisen out of the Act's Indians not taxed language. Senator Trumbull explained that the category of Indians not taxed was an attempted proxy for the Indians over whom the United States lacked complete jurisdiction. The Civil Rights Act was supposed to designate a class of persons who were not a part of our population, so it was supposed to exclude tribal Indians while including Indians who come within the jurisdiction of the United States. The former could not be taxed, in the sense of personal taxes. But, the phrase, excluding Indians not taxed, Trumbull realized, could be misunderstood to encompass Indians who had left their tribal community and permanently settled outside of it, but were not taxed for other reasons, such as because they were not possessed of wealth at 2894. Similarly, making citizenship depend on taxation could allow states to manipulate citizenship eligibility by changing their tax practices. The phrase, subject to the jurisdiction, solved the problem because it avoided excluding from citizenship the children of non-tribal Indians who for whatever reason were not taxed. Tribal Indians were not in any sense subject to the complete jurisdiction of the United States, at 2893. Like temporary visitors, tribal Indians were not subject to our jurisdiction in the sense of owing allegiance solely to the United States. Their internal affairs, including marriages, family matters, intestacy, and payment of personal taxes, were regulated by their tribes. Thus, members of Congress understood the 14th Amendment's language to be more precisely describing, not substantively altering, the set of individuals excluded from birthright citizenship by the Civil Rights Act. Shawan, comment, The Significance of Domicile in Lyman Trumbull's Conception of Citizenship Lash, 101 Notre Dame Rev. With respect to temporary visitors from foreign nations, the phrase was believed to accomplish the same object as the Civil Rights Act's exclusion of those subject to a foreign power. Children born to temporary visitors owed allegiance to another government, the country of their domicile, so they were not subject to the jurisdiction of the United States. The Citizenship Clause simply states in positive terms, subject to the jurisdiction thereof, what the Act stated in negative terms, not subject to any foreign power. The evidence from the decades following ratification confirms that the Citizenship Clause was understood to exclude the children of temporary visitors. There was frequently expressed, enduring, and widespread agreement, from the Reconstruction Congress through the end of the 19th century, and even into the 20th, that the Citizenship Clause did not guarantee citizenship to persons not domiciled here. The executive branch, Congress, courts, states, lawyers, scholars, and commentators generally shared this understanding. The executive branch understood the Citizenship Clause to exclude the children of temporary visitors. In 1873, President Grant's Attorney General George Williams interpreted it to apply only to persons over whom the United States had complete jurisdiction. The word jurisdiction must be understood to mean absolute or complete jurisdiction, such as the United States had over its citizens before the adoption of this amendment. It therefore excluded aliens over whom the United States had only limited jurisdiction, even if they were born here. Across administrations, the executive branch took the same position. A child born on American soil was not an American citizen when he was domiciled in a foreign country. Letter from Section of State Bayard to Winchester, Indiana. By virtue of his foreign domicile, he was, on his birth, subject to a foreign power, and not subject to the jurisdiction of the United States. A child born in this country to a foreign father, when taken by his father abroad, acquires the father's domicile and nationality. Letter from Section of State Frelinghuysen to Kramer, in ID. These statements were not mere abstract positions, but the executive branch's operating rule of decision for decades. When the children of temporary visitors born on American soil claimed to be citizens based on the Citizenship Clause, the executive branch repeatedly denied their claims to citizenship. Joseph Speck was denied citizenship after being born in the United States to parents domiciled in Switzerland. In 1878, Speck claimed to be a citizen after his father returned with him to Switzerland. President Hayes's acting Secretary of State Frederick Seward rejected his claim. Although Speck may have been able to claim citizenship had he been domiciled in the United States, Seward denied his claim because his status, as well as his domicile, according to the well-understood principles of international and municipal law, follows that of the father until the boy attains his majority. Letter from Acting Section of State Seward to Fish, in ID. Ludwig Hosding was denied citizenship after being born in the United States to parents domiciled in Saxony. Hosding's parents were Saxon subjects, temporarily in the United States. Letter from Section of State Frelinghuysen to Casson, in Papers Relating to the Foreign Relations of the United States 395. President Cleveland's Secretary of State Frederick Frelinghuysen explained in 1885 that Hosding was not constitutionally entitled to citizenship. Because Hosding's parents were not domiciled here, he remained subject to any foreign power. Therefore, his attempt to assert citizenship on the ground of birth in the United States was untenable. See also. Richard Gracer was denied citizenship after being born in the United States to parents domiciled in Germany. He was born in 1867 in the state of Ohio. Letter from Section of State Bayard to Winchester, in ID. His father was domiciled in Germany. According to President Cleveland's Secretary of State Thomas Bayard in 1885, Gracer therefore, was on his birth subject to a foreign power, and not subject to the jurisdiction of the United States. He was not, therefore, under the statute and the Constitution a citizen of the United States by birth. The State Department thus denied Gracer's claim to citizenship. Friedrich de Bory was denied citizenship after being born in the United States to parents domiciled in Austria. When de Bory sought protection as an American citizen in 1886 after returning to Europe, Secretary Bayard denied his claim to citizenship. Although de Bory was born in the city of New York, Secretary Bayard explained, his parents were temporarily resident and returned to Europe a few years later. Letter from Section of State Bayard to Lee, in ID. He then remained in Europe, showing that an Austrian domicile was chosen. Secretary Bayard concluded that de Bory's passport must therefore be refused. The child of a woman named Mary Devereux was denied citizenship after being born in the United States in 1889. Devereux was an Irish woman who arrived in New York and promptly went to the hospital to give birth the next day. She was not yet, however, lawfully admitted to the country. Although the baby was undoubtedly born on American soil, it was not an American citizen because Devereux had not yet been lawfully admitted. See letter from Reeve, Acting Solicitor of the Treasury, to Wyndham, Secretary of the Treasury, in 11 documents of the Assembly of the State of New York. President Harrison's administration denied the baby citizenship. I am, therefore, of the opinion that the child in controversy born during the temporary removal of the mother from the importing vessel to a lying-in hospital for her own comfort, pending further examination as to whether she belongs to the prohibited class of immigrants, did not become, by reason of its birth, under such circumstances, an American citizen, see swearer, subject to the complete jurisdiction thereof. These children were not born to diplomats. They were not part of invading armies or Indian tribes. They were simply foreigners, born on American soil but not domiciled here. And they were all denied citizenship under the Citizenship Clause, by those in a better position to know its original meaning than we are today. Webster, Law of Citizenship in the United States, treated historically 109 to 129. Even the most expansive executive interpretation of the Citizenship Clause ultimately denied citizenship to a child born here but domiciled abroad. When François Heinrich, born of parents who ultimately returned to their native Austria, claimed to be an American citizen, President Grant's executive branch did say that he was originally clothed with American nationality. But it then promptly denied Heinrich's claim to American citizenship. Heinrich was instead, despite being born in the United States, a citizen of Austria, where he was domiciled. François Heinrich should be held by the United States to be an Austrian subject, and treated as such. He is not an American citizen. Letter from Section of State Fish to Baron Lederer, in. Congress understood the Citizenship Clause to exclude the children of temporary visitors. Just 2 years after the 14th Amendment was ratified, Congress passed the Enforcement Act of 1870. The Act implemented the Citizenship Clause with the same language that the Civil Rights Act had used, limiting the right to citizenship to persons born here and not subject to any foreign power. Enforcement Act of 1870. The 1870 Act thus incorporated language that expressly excluded the children of temporary foreign visitors, who were subject to the power of the foreign countries in which they were domiciled. If the Citizenship Clause included the children of temporary visitors, who clearly fall outside the reach of the Enforcement Act, then the Reconstruction Congress would have violated its own Citizenship Clause in an act designed to enforce it. C. The parties point to no one who suggested that the 1870 Act was unconstitutional. This court long agreed that the Citizenship Clause did not apply to persons born here to children of temporary visitors. Just 5 years after the Citizenship Clause was ratified, this court explained that the phrase, subject to the jurisdiction, excluded persons not domiciled here. The phrase, subject to its jurisdiction, the court explained, was intended to exclude from its operation children of ministers, consuls, and citizens or subjects of foreign states born within the United States. Then, in Elk, the court again interpreted the clause to require complete jurisdiction, not just bare territorial authority. The court held that to satisfy the Citizenship Clause, a person must not only be born within the territorial limits of the United States, but must be completely subject to the United States political jurisdiction at birth. The Citizenship Clause's evident meaning, this court said, is not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject to its political jurisdiction, and owing it direct and immediate allegiance. The Citizenship Clause thus granted citizenship at birth only to persons who owed no allegiance to any alien power. Of course, the children of temporary visitors were not completely subject to the United States political jurisdiction, did not owe the United States direct and immediate allegiance, and did owe allegiance to an alien power. Justice Harlan dissented in Elk, but he agreed that the Citizenship Clause referred to the same, complete jurisdiction. He dissented only because he thought that someone born in the territorial United States could become a citizen even if he became subject to its complete jurisdiction later in life. On Justice Harlan's view, which was not uncommon at the time, the Citizenship Clause did not require that the person be born while subject to the complete jurisdiction of the United States. Instead, a person could be born in the United States while not subject to its jurisdiction, as John Elk was because he was a member of an Indian tribe at birth, but become subject to its jurisdiction later, as Elk did by abandoning his tribe. On Justice Harlan's view, following the law of domicile, persons became subject to the jurisdiction of the United States by becoming bona fide residents of states and subject to taxation there. See also ID. Explaining that one becomes subject to the complete jurisdiction of the United States by residence in one of the states. Every justice in Elk thus agreed that the Citizenship Clause did not refer to bare territorial authority. The most celebrated 14th Amendment opinion is Justice Harlan's dissent in Plessy v. Ferguson. In that dissent, Justice Harlan disagreed with the Plessy Court's conclusion that the Constitution tolerated state-imposed segregation. Justice Harlan took the position, to be vindicated decades later, that our Constitution is colorblind, and neither knows nor tolerates classes among citizens. He also took a view on whom the Citizenship Clause applied and did not apply to. According to Justice Harlan, the Citizenship Clause did not apply to persons born here who resided abroad. Instead, it gave citizenship to all born or naturalized in the United States and residing here. State officials likewise agreed that the Citizenship Clause excluded persons not domiciled here. Although the Citizenship Clause guaranteed both national and state citizenship, states excluded from citizenship children of transient aliens. Political Code of California, 1, e.g. Reverend Codes of D. 1, the citizens of the state are, all persons born in this state and residing within it, except the children of transient aliens. The complete codes and statutes of the state of Montana, 1, the citizens of the state are, all persons born in this state and residing within it, except the children of transient aliens. Nobody seemed to suggest that these state laws violated the 14th Amendment. Likewise, state judicial precedent held that the Citizenship Clause included children born of foreign parents only, when the parents are domiciled here. To qualify for citizenship, two facts must concur: the person must be born here, and he must be subject to the jurisdiction of the United States according to the 14th Amendment, which means, according to the Civil Rights Act, that the person born here is not subject to any foreign power. The Citizenship Clause thus accepted those born in this country of foreign parents who are temporarily traveling here. Scholars agreed, as well, that the Citizenship Clause required domicile. As early as 1875, Yale Law School professor William Robinson wrote that a native-born citizen was one who was born within the jurisdiction and allegiance of the United States. Notes on Elementary Law. And to be born within the jurisdiction and allegiance of the United States, a person born within the territory of the United States, of alien parents, had to show that those parents were permanently domiciled within the United States. A long list of eminent 19th-century legal scholars, including Thomas Cooley, Francis Wharton, Henry Campbell Black, and Justice Samuel Miller, agreed. Cooley wrote that, a citizen by birth must not only be born within the United States, but he must also be subject to the jurisdiction thereof, and by this is meant that full and complete jurisdiction to which citizens generally are subject, and not any qualified and partial jurisdiction, such as may consist with allegiance to some other government. General Principles of Constitutional Law 243. Francis Wharton explained that children born in the United States, of parents not being here domiciled, are not citizens. Wharton Treatise 1880. See also, Citizenship Clause, excluded children born in the United States to foreigners here on transient residence, such children not being by the law of nations subject to the jurisdiction of the United States. Henry Campbell Black, of Black's Law Dictionary, wrote, "If a stranger or traveler passing through the country, or temporarily residing here, has a child born here, who goes out of the country with his father, such child is not a citizen of the United States, because he was not subject to its jurisdiction." Handbook of American Constitutional Law 458. By contrast, the children, born within the United States, of permanently resident aliens, are citizens. And, Justice Samuel Miller confirmed in his lectures on constitutional law that if a traveler, temporarily residing in this country, has a child born here which goes out of the country with its father, such child is not a citizen of the United States, because it was not subject to its jurisdiction. Lectures on the Constitution of the United States 279. Scholar after scholar confirmed that domicile was required for citizenship. The words, "subject to the jurisdiction thereof," excluded the children of foreigners transiently within the United States. Morse, Treatise on Citizenship 248. The Citizenship Clause excluded the children of foreign subjects, born while the latter transiently sojourn here. Times 113, 146. The children of foreigners, in transient residence, are not citizens, their fathers being subject to the jurisdiction less completely than Indians. Hall, The Foreign Powers and Jurisdiction of the British Crown. See also Hall, International Law 236-237. In the United States it would seem that the children of foreigners in transient residence are not citizens. The requirement of personal subjection to the jurisdiction thereof excludes children of persons passing through or temporarily residing in this country. Winchester, Citizenship in its International Relation. As immigration laws became more restrictive, some adopted the view that children must be born to citizens to obtain citizenship by birth. In contesting that view, its detractors spoke in terms of domicile. Prominent jurist Henry Ide, for example, published an article arguing that whether the very fact of birth in our country renders one subject to the jurisdiction thereof depends on the question of domicile. The jurisdiction referred to in the amendment means political national jurisdiction and not merely the jurisdiction of our laws. One born of parents temporarily in our country is not constitutionally guaranteed citizenship because he is not born with the stamp of domicile, so the elements of national jurisdiction are wanting. By contrast, Ide contended, persons domiciled but not naturalized are de facto though not de jure citizens of the country of their domicile, so their children should be deemed de jure as well as de facto citizens. In United States v. Wong Kim Ark, this court interpreted the Citizenship Clause to apply to a person born and domiciled here. The case, and the arguments made in it, arose out of the unique circumstances of Chinese immigration in the late 19th century. Hundreds of thousands of Chinese immigrated to the United States during this time. They were met with considerable hostility. By statute, Chinese settlers could not be naturalized. See in Re A Yup, 225 Fong Yuting v. United States. Congress then banned Chinese immigration in the Chinese Exclusion Act of 1882. See Act of May 6, 1882, ch. 126-61. Meanwhile, if a Chinese person renounced his allegiance to China, the Chinese government could behead him upon his return, sell his family as slaves, and banish his relatives. See Wong Kim Ark. Justice John Marshall Harlan, Lectures on Constitutional Law, 1897-98, Lecture No. 27, in 81 Geo. Washington. Given the era's concern with dual citizenship, this policy made it even more difficult for Chinese immigrants to fully settle in the United States. Unlike other settlers, then, the Chinese, even those who lived here and wished to remain, had no path to citizenship and no means of freeing themselves from the grasp of China. The executive branch took the view that because domicile no longer ensured full integration into the American body politic, the Citizenship Clause's phrase, "subject to the jurisdiction," must require more than domicile. That view would entail that a child born to Chinese parents domiciled in this country was not a citizen. Instead, the executive branch sought to replace the requirement of domicile, which would make any child of domiciled Chinese immigrants a citizen, with the requirement that a person's parents already be citizens. Ctg. In Re Luk Tin Sing. Acting on this view, the government in 1895 denied citizenship to a man domiciled in the United States from birth. The stipulated facts were these. Wong Kim Ark was born in San Francisco in 1873, and his legal home was California. His parents were not temporary visitors. They were not illegal aliens. CTR, of record in United States v. Wong Kim Ark. Instead, Wong's parents had done everything within their power to express their desire and intent to become Americans. Post. They came to settle in America. After Wong traveled to China in 1890, he returned and was admitted to the United States as a citizen. But, after his second trip to China in 1894, the American customs collector denied him permission to re-enter. The government claimed, for the first time, that Wong was not a citizen. This court's decision in Wong Kim Ark concerned only persons already domiciled in the United States. As stated in the government's brief, the question presented by this appeal was, is a person born within the United States of alien parents domiciled therein a citizen thereof by the fact of his birth? The government agreed that Wong was born and domiciled in the United States. See also in fact, the thrust of the government's opening brief was that birth and domicile were insufficient. The government lamented the mistakes made and the misunderstanding arising from failing to distinguish between nationality and domicile. 1895, number 904. Also reply brief in Wong Kim Ark. It disapproved of the decisions of some of our attorneys general and secretaries of state for their error of failing to distinguish between nationality and domicile. It acknowledged that state citizenship was based on domicile, but argued that a different rule should govern national citizenship to preserve the distinction between state and national sovereignty. The Constitution does not countenance, the government argued, making domicile an element of nationality. The court was not persuaded and ruled that Wong, born in the United States to parents domiciled here, was a citizen. The court found it so important that Wong and his parents were domiciled in the United States at the time of his birth that it gratuitously insisted upon that fact throughout its opinion. The court's introductory paragraph stated 7 different ways that Wong was domiciled in the United States. He was born to parents who were, at the time of his birth, domiciled residents of the United States. His parents were enjoying a permanent domicile and residence therein at San Francisco. His parents continued to reside and remain in the United States. He, ever since his birth, has had but one residence, to wit, in California, within the United States. He had there resided. He never lost or changed that residence. And he never gained or acquired another residence. 2 paragraphs later, the court confirmed that its decision was limited to persons born and domiciled in the United States. The question presented by the record is whether a child born in the United States, of parents of Chinese descent, who, at the time of his birth, are subjects of the Emperor of China, but have a permanent domicile and residence in the United States, becomes at the time of his birth a citizen of the United States. Then, if that were not enough, the court reiterated the same limits to its opinion in its final paragraph. This case presented for determination the single question stated at the beginning of this opinion, namely, whether a child born in the United States, of parents of Chinese descent, who, at the time of his birth, are subjects of the Emperor of China, but have a permanent domicile and residence in the United States, becomes at the time of his birth a citizen of the United States. The opinion itself was filled with meandering dicta. The court's interpretation of the Citizenship Clause evolved over the course of the opinion, before landing on an interpretation that limited citizenship at birth to persons domiciled here. At first, the opinion stated that the rule of American citizenship was the feudal principle of birth on the soil with only 2 exceptions: 1, the child of an ambassador or other diplomatic agent of a foreign state, and 2, the child of an alien enemy in hostile occupation. Then, after considering more evidence and arguments, the opinion reformulated the rule to include a 3rd exception: 1, children of members of the Indian tribes, 2, children born of alien enemies in hostile occupation, and 3. Children of diplomatic representatives of a foreign state. Then, after discussing more considerations and authorities, the opinion reformulated the rule with at least 5 exceptions and a residence requirement: all children here born of resident aliens, with the exceptions or qualifications of 1. Children of foreign sovereigns, 2. Children of foreign ministers, 3. Children born on foreign public ships, 4. Children of enemies within and during a hostile occupation of part of our territory, and 5. Children of members of the Indian tribes owing direct allegiance to their several tribes. Then, the court concluded by reiterating an explicit domicile requirement. Outside of these 5 categories, the Citizenship Clause covers all other persons, of whatever race or color, domiciled within the United States. So, although these various statements are both dicta and irreconcilable, as is much of the opinion's reason ing, the court's most complete rule statement was limited to persons, like Wong, born and domiciled in the United States. Chief Justice Fuller's dissent, joined by Justice Harlan, did not accept the government's primary theory that, to qualify for birthright citizenship, a child born in this country must also be born to citizen parents. Such a position, after all, was in tension with Justice Harlan's twice-stated view that the Citizenship Clause turned on complete jurisdiction, ELK, or residence, plessy, 2 terms that corresponded to domicile. Chief Justice Fuller's dissent instead took the position that the Citizenship Clause recognized an essential difference between birth during temporary, and birth during permanent, residence. On his account, the Citizenship Clause excluded children born of aliens whose residence was merely temporary. Chief Justice Fuller nonetheless dissented because he rejected the premise that Wong's parents were domiciled here at the time of his birth. He explained that because Chinese law purported to bind Wong's family even after they had settled here, the family cannot acquire a permanent home here, no matter what the length of their stay may be. See also ID. And see also Justice John Marshall Harlan, Lectures on Constitutional Law, in 81 Geo. Washington. Thus, Chief Justice Fuller and Justice Harlan dissented because, in their view, Wong and his parents were not actually domiciled in the United States at the time of his birth. Wong Kim Ark left in place the same rule that existed before: a child of a domiciliary was a citizen, but a child of a temporary visitor was not. The effect of Wong Kim Ark, a legal scholar explained shortly after it was published, is to make citizens of the United States by virtue of the 14th Amendment all persons born in the United States of alien parents permanently domiciled and residing here. Guthrie, Lectures on the 14th Article of Amendment to the Constitution of the United States 57. As a 14th Amendment treatise published in 1901 explained, it remained the case that mere birth within American territory does not always make the child an American citizen. Brannan, Rights and Privileges Guaranteed by the 14th Amendment to the Constitution of the United States 25. The Citizenship Clause excluded children of aliens born here while their parents are traveling or only temporarily resident. Wong Kim Ark was limited to alien parents, not temporarily resident here, but permanently domiciled. Brannan 29. On this understanding of Wong Kim Ark, temporary visitors' children were still excluded from citizenship. In the United States, William Edward Hall wrote 6 years after Wong Kim Ark, it would seem that the children of foreigners in transient residence are not citizens. A 1901 international law treatise explained that children born in the United States to foreigners here on transient residence are not citizens, because by the law of nations they were not at the time of their birth subject to the jurisdiction of the United States. When a father has domiciled himself in the Union, John Westlake wrote in 1904, his children are citizens. But, when he is in the Union for a transient purpose, his children born within it have his nationality. This understanding was widespread after Wong Kim Ark. A person born in this country of alien parents was a citizen only if those parents were domiciled. A child born in the United States is a citizen when domiciled, but not when his parents left after being temporarily resident. Wharton, Conflict of Laws 44-45. A child born on American soil to a stranger or traveler passing through the country was not a citizen, but a child born within the United States of permanently resident aliens was a citizen. Black, Handbook of American Constitutional Law. The rule remained, in other words, that children of foreigners and transient residents were excluded from citizenship, even though born in the United States. Government officials generally agreed. In 1910, a Department of Justice report explained that it has never been held, and it is very doubtful whether it will ever be held, that the mere act of birth of a child on American soil, to parents who are accidentally or temporarily in the United States, operates to invest such child with all the rights of American citizenship. Spanish Treaty Claims Common, Final Report of William Wallace Brown 124. The Citizenship Clause did not mean that jurisdiction to which the bodily form of the child is subject from the moment of its birth, but that larger jurisdiction, which, though difficult to define, is well known and understood, the difference between the jurisdiction which is exercised over a visitor and that over one domiciled, which difference may be seen at a glance. Even this court described Wong Kim Ark in limited terms. It read Wong Kim Ark to apply to aliens with a permanent domicile and residence in the United States. Wong Kim Ark, in its telling, covered children born to parents permanently domiciled in the United States. Throughout this period, Congress left in place the same statutory language that it originally enacted in 1866 and then reenacted in 1870, so American citizenship was limited to persons not subject to any foreign power. See Enforcement Act of 1870, see also Reverend Stat, all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are declared to be citizens of the United States. All persons born in the United States and not subject to any foreign power are declared to be citizens of the United States. The Nationality Act of 1940 replaced that language with the same language, in relevant part, as the Citizenship Clause itself. A person born in the United States, and subject to the jurisdiction thereof, is a citizen. Congress reenacted that provision verbatim in the 1952 Immigration and Nationality Act, INA. 236. It remains the governing statute today. C. In the 20th century, executive practice repurposed the Citizenship Clause to treat the children of temporary visitors and illegal aliens as citizens. An assistant solicitor named Richard Flournoy prominently argued that the Citizenship Clause does include the children of temporary visitors. He disagreed with a number of writers, who held that, in order that a person born in the United States of alien parents may have American citizenship, his parents must have been domiciled in this country at the time of his birth. Although he acknowledged that Wong Kim Ark did not directly decide the precise point, he said that the Citizenship Clause should be read to incorporate a rule that originated with the feudal system, under which all persons, with certain limited exceptions, born within the fief of an overlord were held to owe fealty to him and allegiance to the sovereign. Flournoy acknowledged that some consequences of his theory were absurd. President Franklin Roosevelt's administration adopted the view that the Citizenship Clause applied to the children of temporary visitors. C1. In 1995, some 127 years after the Citizenship Clause was enacted, President Clinton's Office of Legal Counsel endorsed the same view. It explained that the right to American citizenship for the children of illegal aliens and temporary visitors is fundamental to our liberty as we understand it. Many in Congress disagreed with the executive branch's view. As late as the 1990s, Senator Harry Reid sponsored bipartisan legislation to clarify that the child of an illegal alien or temporary visitor would not be a citizen of the United States or of any state solely by reason of physical presence within the United States at the moment of birth. S. 1351, 103d Cong First Session, no sane country, Senator Reid argued would offer a reward for being an illegal immigrant. Others supported similar legislation. The question was not prominent in judicial opinions in the 20th century. One of the first substantial discussions arose 105 years after Wong Kim Ark, when Judge Posner treated the matter as unsettled. A constitutional amendment may be required to change the rule whereby birth in this country automatically confers citizenship, he wrote, but I doubt it. Oforgie v. Ashcroft at 609, 621, concurring opinion. The purpose of the rule was to grant citizenship to the recently freed slaves, and it would not be flouting the Constitution to put an end to the nonsense. Some took advantage of the executive branch's recent policy of granting citizenship to anyone born on American soil. The policy encouraged birth tourism, the practice of traveling here with temporary authorization solely to give birth and obtain citizenship for one's children, then returning to raise them in another country. Today, birth tourism companies reportedly collect large fees from wealthy foreigners to facilitate their trips to give birth in the United States. Large numbers of children are born in the United States each year to parents who are temporarily present here in order to obtain citizenship for their children. Hack, Why Chinese Parents Come to America to Give Birth, Marketplace, https://www.marketplace.org/story/2019/03/06/why-Chinese-parents-come-America-give-birth. See also. Upon taking office, President Trump issued an executive order that expressed the executive branch's interpretation of the Citizenship Clause. The Citizenship Order adopts the view that the 14th Amendment does not guarantee citizenship at birth to the children of temporary visitors and illegal aliens. Section 1 of the order interprets the scope of the Citizenship Clause. It states that someone born in the United States is not guaranteed citizenship if that person is born here to lawful temporary foreign visitors or to illegal aliens. By contrast, a person is guaranteed citizenship if he is born here to lawful permanent residents or citizens. Section 2 of the order then directs the executive branch to implement this interpretation by not issuing documents recognizing the citizenship of persons in the two excluded categories and by not accepting documents issued by state, local, or other governments purporting to recognize the citizenship of such persons. Those directives are prospective. They apply only to persons who are born within the United States after 30 days from the date of this order. Section 3 of the order directs executive officials to implement the order with appropriate regulations, policies, and guidance. The President's initiative generated a groundswell of new scholarship into the original meaning of the Citizenship Clause. A wide range of originalist scholars have concluded that the 20th century executive practice was mistaken and that the order has substantial lawful applications. See generally, e.g. Lash, 101 Notre Dame Rev 101 Epstein, The Myth of Birthright Citizenship Werman, Jurisdiction and Citizenship, 49 Harv. Pub Government 73 Barnett, Trump is Right on Birthright Citizenship, Wall Street Journal, March 31, 2026 Hamburger, Allegiance, Birthright and Citizenship, Law and Liberty, https://lawliberty.org/allegiance-birthright-and-citizenship, archived at perma.cc/s9jb-cnep. Before the order went into effect or executive agencies implemented it, several district courts universally enjoined its implementation. This court partially stayed those injunctions in Trump v. Casa, Inc. because they exceeded the district court's remedial authority. Several plaintiffs immediately filed new actions, and several district courts again enjoined the executive branch from implementing the order. This case arises from one of those actions. 3 plaintiffs sued on behalf of a putative class. The plaintiffs, who proceed under pseudonyms, are each illegal aliens or lawful temporary visitors. The first plaintiff, a Honduran citizen, was expecting a baby due in October 2025. The other 2 plaintiffs, one Taiwanese citizen and one Brazilian citizen, did not allege that they were expecting a baby. None alleged that any of their children will be domiciled in the United States. As a right of action, plaintiffs invoked the Citizenship Clause itself, the INA, and the Administrative Procedure Act. They sued on behalf of a putative class of all children who would be ineligible for citizenship under the President's order, as well as those children's parents. And they sought to have the order declared unconstitutional and unlawful in its entirety. Complaint in No. 25, CV, 244, NH, ECF Document 1. The district court ruled for the plaintiffs. It interpreted the Citizenship Clause to guarantee citizenship to the children of all lawful temporary visitors and illegal aliens. As to relief, the district court certified a provisional universal class under Federal Rule of Civil Procedure 23, b-2, which states that class actions may be maintained if the defendant has acted or refused to act on grounds that apply generally to the class, so that final injunctive relief is appropriate respecting the class as a whole. The certified class consisted of all current and future persons, born on or after February 20, 2025, who fall within the two categories covered by the President's order. Sup. 3D 80, 105. The District Court entered a class-wide preliminary injunction prohibiting enforcement of the Citizenship Order against anyone in the class, meaning anyone at all. The Court today affirms the District Court's universal class injunction. It holds that the 14th Amendment guarantees citizenship to all children born here to lawful temporary visitors or illegal aliens. On the Court's telling, the law of citizenship in the United States was fixed to an English rule that everyone born on the soil was permanently bound to serve the sovereign. Ante. This principle of permanent feudal allegiance, according to the Court, was repurposed into a rule of citizenship and adopted by all of the states. Ante. The rule's universal acceptance was embodied by an 1844 state equity decision called Lynch v. Clark. The rule extended citizenship to all persons born within United States territory, except three categories: children of foreign representatives, children over whom the government lacked actual power, and children of Indians and tribes. Ante. Those three exceptions were then adopted in the Civil Rights Act and the Enforcement Act by the phrase, "not subject to any foreign power," and in the Citizenship Clause by the phrase, "subject to the jurisdiction thereof." Ante. This Court's Wong Kim Ark opinion 3 decades later, the Court says, confirmed the same rule. Ante. Before proceeding to the merits, I briefly note 3 threshold impediments to the Court's decision today that the Court leaves unaddressed. First, the Court has an independent obligation, Summers v. Earth Island Institute, to ensure that every single recipient of class action relief has standing, TransUnion LLC v. Ramirez. But, today it affirms an injunction on behalf of a class that includes all current or future persons subject to the order indefinitely into the future. Sup. 3d. Contra, Lujan v. Defenders of Wildlife C. Casa, explaining that class judgment binds the whole class. Second, the Court cannot grant relief to any party without a right of action. But, it grants relief here on the basis of a suit brought under the Citizenship Clause, the INA, and the APA. The Citizenship Clause and the INA's equivalent, by their terms, create no right of action. The APA authorizes suits challenging final agency action, but the plaintiffs did not allege any final agency action. Third, because respondents sought to invalidate the Citizenship Order in its entirety and the District Court granted facial relief, the plaintiffs bear the burden to show that all applications of the order are unlawful. See Post. Under this Court's precedent, facial challenges require plaintiffs to establish that no set of circumstances exists under which the order would be valid. Moody v. NetChoice, LLC. To prevent federal courts from invading the political branch's interest in effectuating policies enacted by representatives of the people, Maryland v. King, facial invalidation must remain rare and hard to win. The Court's decision to hold the Citizenship Order facially unconstitutional, in other words, makes it unlawful for the President to enforce the order against a single person. He cannot enforce the order against a child of an alien enemy or a child of a foreign spy. He cannot even enforce the order against children who are raised in foreign countries, join foreign armies, and fight wars against the United States. The Court, without considering any of these individual circumstances, holds unconstitutional the application of the Citizenship Order in all of them. In my view, the Citizenship Order is not facially unconstitutional. The order is consistent with the original meaning of the Citizenship Clause, at least insofar as it applies to children born to parents, here lawfully or unlawfully, who are not domiciled in the United States. The Citizenship Clause was enacted for people who were born in this country and called it home. It was enacted for freed slaves such as Dred Scott, who had a domicile here and therefore were entitled to sue as citizens. Brief for Dred Scott 6. It was enacted for men such as Frederick Douglass, who demanded citizenship not as aliens nor as exiles, but as Americans. Its authors and supporters promised, over and over again, that it would exclude the children of persons temporarily resident here, whom we would have no right to make citizens, at 572. In Senator Trumbull's words, what do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means. And, for decades after ratification, it was interpreted by all three branches of government and by a wide range of legal authorities to be limited to people who were already Americans. The ordinary principles of constitutional interpretation, the ones on which this court typically relies when presented with a constitutional question such as this one, support the conclusion that the Citizenship Clause requires domicile. That conclusion is supported by the constitutional text, contemporaneous evidence, early executive practice, early legislative practice, judicial precedent, and all of the other indicators of original public meaning. The court's alternative account does not have a similar degree of support. The Citizenship Order is therefore, insofar as it applies to persons not domiciled here, consistent with the Citizenship Clause. It is consistent with the Citizenship Clause in its exclusion of the children of lawful temporary visitors, such as birth tourists. The exclusion of the children of lawful temporary visitors, who are, by definition, not domiciled here, was originally a matter of widespread agreement. As to them, the Citizenship Order does exactly what the executive branch did for most of the rest of the 19th century, what this court said that it could do, and what scholars for decades confirmed that it could do. And, the order is at least facially consistent with the Citizenship Clause in its exclusion of the children of illegal aliens because at least some such persons are not domiciled here, and therefore also are not citizens. The constitutional text supports the conclusion that the Citizenship Clause requires domicile. The Citizenship Clause guarantees citizenship to persons who were both born in the United States and subject to the jurisdiction thereof. At the time that the Citizenship Clause was adopted, the phrase, subject to the jurisdiction, referred to the legal relationship that a person had to the government of his domicile. That legal relationship included the government's power over the domiciliary's personal affairs, power to regulate his conduct everywhere, and power to impose personal taxes on him. See Story on Conflict of Laws 51-52 in Re Hood's estate. It also included the reciprocal relationship of protection abroad and primary allegiance. A government lacked the powers associated with this relationship, and thus lacked complete jurisdiction over temporary visitors. Temporary visitors remained subject to the jurisdiction of their home country. Hence, a person was subject to the jurisdiction of the government where he was domiciled. This interpretation accords with the contemporaneous evidence that would have informed the public meaning of the text. It is consistent with the Civil Rights Act's requirement that citizens be not subject to any foreign power. A person born in the United States to temporary visitors was subject to a foreign power, namely, the power of his home country in which he retained his domicile. It is consistent with the early American law of state and national citizenship, which turned on domicile. It overrules Dred Scott because it restores the rule of decision under which Scott should have won, namely, that he was entitled to sue as a citizen of Missouri because he had a permanent domicile in the state. Dred Scott brief for Dred Scott 6. It excludes tribal Indians because they remained first and foremost subject to their separate nations, which alone had complete jurisdiction over them. And it ensures that the freedmen, who were clearly American, would not be denied citizenship based on a racial caste system. In other words, the phrase, subject to the jurisdiction, meant what the drafters and ratifiers said that it meant, complete jurisdiction, at 2893, fully and completely subject to the jurisdiction of the United States, ID. The jurisdiction of the United States in every sense, ibid, and a full and complete jurisdiction, coextensive in all respects with the constitutional power of the United States, whether exercised by Congress, by the executive, or by the judicial department, that is to say, the same jurisdiction in extent and quality as applies to every citizen of the United States now, ID. The phrase thus also had the implication that the drafters and ratifiers said that it had, the children of temporary visitors were not citizens. The Citizenship Clause, they said, would not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers. After all, we would have no right to make citizens of persons temporarily resident in the United States. The court's alternative theory is more difficult to square with the text. The court defines the phrase, subject to the jurisdiction of the United States to refer to the power of the United States to govern those within its territory. Ante. It then says that at least 3 categories of persons born within United States territory are not subject to its jurisdiction. First, a person is not subject to the jurisdiction of the United States when the government, impliedly waives, its regulatory power over him. Ante. See also ante. The court understands this category to exempt all children of representatives of foreign sovereigns, endeavoring to capture a long-standing principle that such children were not entitled to citizenship. Ante. Although the court gestures toward diplomatic immunity as a basis for this exception, diplomatic immunity extends to only a narrow set of diplomatic officials, not to all foreign representatives. Most foreign officials receive a partial immunity, such as immunity for their official acts. See Department of State, Diplomatic and Consular Immunity, www.state.gov/WP-content/upload/2019/07/2018-dipconimem_v5_web.pdf, archived at perma.cc/lk63-c3yl. But, partial immunity cannot render a person not subject to the jurisdiction of the United States for 14th Amendment purposes. After all, a variety of clearly American government officials, such as judges, prosecutors, and police officers, have similar partial official immunity. Furthermore, if the political branches can deny someone citizenship by waiving their regulatory power over him, then they can deny citizenship to any child in America, even if his family has lived here for generations and has no other home. The better explanation for excluding the children of foreign representatives is that they were not domiciled in the United States. Second, the court says, a person is not subject to the jurisdiction of the United States when the government lacks actual power over him. Ante. This category, presumably, is an attempt to accommodate the consensus that citizenship would not have been granted to the children of foreign invaders. See Brief for Respondents 1, Recognizing Exception for a Person in an Occupying Army, CASA, Recognizing Exception for a Person Born of Alien Enemies in Hostile Occupation. But, while the child of a foreign invader is of course not constitutionally entitled to citizenship, it is not because America lacks actual power over him. If it were, then citizenship could be denied to any American over whom the government happened to lack actual power at birth. The more likely reason why foreign invaders are not citizens is that they too are foreign and not domiciled here. Third, the court says, a person is not subject to the jurisdiction of the United States when he is a member of an alien and sovereign nation. Ante. This category reflects the court's attempt to accommodate the historical record that the Citizenship Clause excluded the children of Indians in tribes. But, the court cannot explain why tribal Indians were not subject to the jurisdiction of the United States if they happened to be born outside Indian lands while foreign temporary visitors were. It is true that tribal Indians belong to alien and sovereign nations and that the United States' relations with them implicated inter-sovereign concerns. Ante. But, temporarily visiting foreigners also belong to alien and sovereign nations, and the United States' relations with them also implicate inter-sovereign concerns. It is difficult to understand why China, for example, would be less alien or less sovereign than the Cherokee nations. It is also difficult to understand why tribal Indians would be less entitled to American citizenship if born on non-Indian land within the United States than children of birth tourists who immediately returned to China. The court's definition also cannot be reconciled with the contextual evidence that would have informed the meaning of the Citizenship Clause. The court does not attempt to explain how its reading of the Citizenship Clause comports with the Civil Rights Act's citizenship provision. The court does not present evidence that the children of temporary visitors were not subject to any foreign power, as the Civil Rights Act required. Temporary visitors were subject to the foreign power of the government of their domicile. See also. The court also does not present any evidence that the Citizenship Clause had a different meaning from the Civil Rights Act. As no party here disputes, the two provisions were agreed to have been synonymous with respect to foreigners. See at 2890. As the plaintiff's counsel put it, the framers were trying to do the same thing with the language in both. Tr. of Oral Arg 106-107 ID. The court likewise cannot explain the evidence that citizenship in this country was instead based on domicile. It does not meaningfully engage with the congressional debates, during which this provision was extensively discussed. And, it has no account of why so many legislators made so many statements irreconcilable with its view. See Ibid. In fact, the court does not even identify anyone who expressed the feudal principle in the relevant language, not subject to any foreign power, or subject to the jurisdiction of the United States. The closest that it comes is Lynch v. Clark's use of the phrase, within the jurisdiction, language that denotes territorial jurisdiction, Schooner Exchange v. McFadden. But, Congress conspicuously chose not to use that broader territorial phrase in the Citizenship Clause. Notably, the 14th Amendment elsewhere says that no state may deny to any person within its jurisdiction the equal protection of the laws. The Citizenship Clause does not use that territorial phrase. C. Explaining that the Equal Protection Clause refers to all persons within its jurisdiction, and that the phrase subject to the jurisdiction thereof means something other than within the jurisdiction. Thus, while jurisdiction can refer to mere territorial jurisdiction, which a government of course exercises over temporary visitors, Schooner Exchange, the Citizenship Clause did not adopt that sense of jurisdiction. I would not interpret subject to the jurisdiction to refer to the exclusion of three bespoke categories of persons whose relationship to the sovereign was not described in those terms. There is a simpler interpretation of the text that was expressly endorsed by those closer in time to ratification: children born to diplomats, hostile alien occupiers, and Indians and tribes were not citizens because they were not subject to the complete jurisdiction of the United States. For the same reason, the children of foreign temporary visitors, who were also not subject to the complete jurisdiction of the United States, were also not citizens. Practice and precedent immediately and long following ratification support the same conclusion. In constitutional law, this court often pays close attention to how government officials interpreted and applied a constitutional provision shortly after its enactment. Here, the executive branch, Congress, and the judiciary all largely interpreted the Citizenship Clause to require domicile in the decades following ratification. The executive branch regularly denied citizenship to the children of temporary visitors under the Citizenship Clause. The executive branch's position, from the outset, was that the Citizenship Clause excluded the children of aliens who were not subject to the complete jurisdiction of the United States. C. Therefore, a child born in the United States but domiciled abroad was, on his birth, subject to a foreign power and not subject to the jurisdiction of the United States. Letter from Section of State Bayard to Winchester, Indiana. Many executive decisions under the Citizenship Clause denied citizenship to children born but not domiciled here. D1a. In recorded, reasoned decisions, the Hayes, Cleveland, and Harrison administrations, in accordance with the opinion of President Grant's Attorney General, all denied citizenship to children born in the United States but not domiciled here, who also did not satisfy any of the exceptions to the court's rule. D1a. On the court's account, each of these administrations, Republican and Democratic, over the course of multiple decades, and close in time to ratification, acted in defiance of the Constitution, seemingly without objection. Against this settled course of practice, the court can find only a single executive decision from the entire 19th century that it believes supports its interpretation. Ante. But, in that case, the executive branch ultimately ruled that the claimant, Francois Heinrich, was not a citizen. Heinrich was born on American soil and did not fall into any of the court's three exceptions, but Secretary of State Hamilton Fish still concluded that he was not an American citizen, because he resided in Austria. Letter to Baron Lederer, in. The court understands the executive branch to have concluded that Heinrich was originally clothed with American nationality, but then lost that citizenship upon returning to his domicile abroad. Ante. Even the court is thus forced to embrace an interpretation of the Citizenship Clause that allows the political branches to deny citizenship to persons born here to temporary visitors. On that interpretation, the political branches can deny citizenship to such persons once they return home. Beyond that single case, the court does not dispute that the many other 19th-century executive decisions were incompatible with its view. And it has found no examples of the executive branch actually affording the privileges of citizenship under the Citizenship Clause to a person born here while domiciled abroad. The executive branch instead repeatedly took the position that the Citizenship Clause required domicile. Congressional practice supports the same conclusion. Early congressional enactments provide contemporaneous and weighty evidence of the Constitution's meaning. Utah v. Evans, internal quotation marks and alterations omitted. Congress could have enacted a statute that referred to the court's three categories of exceptions. Instead, in 1870, the Reconstruction Congress reenacted the Civil Rights Act, which expressly excluded all persons subject to any foreign power. Once again, a foreigner who was not domiciled here remained subject to a foreign power, namely, his home country. Nobody in Congress, as far as I am aware, argued that this exclusionary language violated the Citizenship Clause. Congress left the language excluding persons subject to any foreign power in place until 1940. Reverend statutes, all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are declared to be citizens of the United States. All persons born in the United States and not subject to any foreign power are declared to be citizens of the United States. It was the governing rule for the first 72 years after ratification. Such contemporaneous legislative exposition of the Constitution, acquiesced in for a long term of years, fixes the construction to be given its provisions. The court has no explanation for the Reconstruction Congress's 1870 decision to exclude from citizenship all persons subject to any foreign power. It appears to concede that it cannot reconcile its interpretation of the Citizenship Clause with that statute. And the court recognizes that every child born to temporary visitors was subject to a foreign power. See also Part I, B, 2b. According to the court, then, Congress defied the Citizenship Clause immediately after enacting it. Early judicial precedent supports the same conclusion. In 1873, 5 years after ratification, this court described the Citizenship Clause in a manner that is, on the court's view, indefensible. It stated that the clause excluded from its operation children of citizens or subjects of foreign states born within the United States. The court rejects that position today, but declines to address its previous interpretation. Likewise, in 1884, this court interpreted the Citizenship Clause to require that a person be not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject to its political jurisdiction, owing it direct and immediate allegiance, and owing no allegiance to any alien power. Elk id. The court also rejects that position today. Decades of post-ratification scholarship interpreting the Citizenship Clause confirmed this view. Most interpreters of the Citizenship Clause concluded that it required domicile. The Citizenship Clause, scholars said, required that a child born here of alien parents show that those parents were permanently domiciled within the United States. Robinson, Notes on Elementary Law. It excluded those with allegiance to some other government. Cooley, General Principles of Constitutional Law. Children born in the United States, their parents not being here domiciled, are not citizens. The words, subject to the jurisdiction thereof, excluded the children of foreigners transiently within the United States. Morse, Treatise on Citizenship. Children, born in the United States to foreigners here on transient residence, were not subject to the jurisdiction of the United States. A child born here, to parents temporarily residing, was not a citizen of the United States, because it was not subject to its jurisdiction. Miller, Lectures on the Constitution of the United States. Many more agreed, the Citizenship Clause excluded the children of foreign subjects, born while the latter transiently sojourn here. Times. The children of foreigners, in transient residence, are not citizens. Hall, Foreign Powers and Jurisdiction of the British Crown. If a stranger or traveler passing through the country has a child born here, who goes out of the country with his father, such child is not a citizen. Black, Handbook of American Constitutional Law 458. Children of foreigners and transient residents are not citizens. One born of parents temporarily in our country, is not constitutionally guaranteed citizenship because he is not born with the stamp of domicile, so that elements of national jurisdiction are wanting. The Citizenship Clause excludes children of persons passing through or temporarily residing in this country. Winchester, Citizenship in its International Relation, 31 AM. Rev. *****. The court does not attempt to match this post-ratification evidence. To the contrary, the court acknowledges that, at least by the 1880s, the Citizenship Clause was understood to require domicile by the government, the executive branch, the State Department, scholars, and treatises. The court, though, proposes that this widespread understanding was not evidence of the original public meaning of the Citizenship Clause, but a rebellion against it. The scholars, courts, and government officials who held that domicile was required, the court says, were engaged in a law reform effort. Their motive, the court seems to say, was to deny citizenship to Chinese immigrants, especially around the election of President Cleveland, the first Democrat to hold the office since the Civil War. On this basis, the court suggests ignoring the considerable post-ratification practice and scholarship that is incompatible with its view. The court's account does not make sense. To begin, the post-ratification evidence against the court's view begins not nearly 2 decades after the 14th Amendment's ratification, but immediately. Well before the court has any explanation for a departure from its view, all 3 branches of the federal government had already rejected it. In 1870, Congress interpreted the Citizenship Clause to require that a child born here be not subject to any foreign power. In 1873, the Supreme Court interpreted the Citizenship Clause to exclude from its operation children of citizens or subjects of foreign states born within the United States. And, the same year, President Grant's Attorney General interpreted the Citizenship Clause to exclude the children of aliens, over whom the United States had limited jurisdiction even though they were born here. If all 3 branches of the federal government were not enough, many others concurred during these first 2 decades. The court cannot explain why, in the 1870s, William Robinson wrote that children, born within the territory of the United States, of alien parents, were not citizens unless permanently domiciled within the United States. Robinson, Notes on Elementary Law 70. Why California excluded from citizenship, children of transient aliens, Political Code of California, 1. Why Representative Ebenezer Hoar, President Grant's first Attorney General and one of the nation's most eminent jurists, interpreted the Citizenship Clause to require domicile, and why the executive branch denied citizenship to a child born here but domiciled abroad, letter from Acting Section of State Seward to Fish, in. The court likewise cannot explain why, in 1880, Thomas Cooley wrote that the Citizenship Clause excluded children who had any allegiance to some other government. General Principles of Constitutional Law in the United States of America 243. The court's theory does not even explain the later evidence that it characterizes as a revisionist project. If, as the court suggests, various government officials and scholars were trying to prevent the children of Chinese immigrants from being citizens, then they would not have proposed a domicile requirement alone. They would have needed to propose a citizenship requirement. As Wong Kim Ark exemplifies, many Chinese immigrants were already domiciled here, they simply were ineligible for formal naturalization. Accordingly, when the executive branch did attempt to exclude the Chinese in the 1890s, it argued against the domicile ruled at D. 3. Meanwhile, as far as I can tell, the people excluded by the domicile requirement were not Chinese, but mostly European. Children such as Joseph Speck of Switzerland, Ludwig Hosding of Saxony, Richard Gracer of Germany, Friedrich de Bory of Austria, and the child of Mary Devereux of Ireland are unlikely targets of a campaign of anti-Chinese discrimination. The D1A. The more likely explanation for why so many Americans stated that the Citizenship Clause required domicile is that the Citizenship Clause required domicile. Many other indicators of original public meaning support the domicile requirement. I briefly address 3. First, if the court were right that the Citizenship Clause did not require domicile, then it would have increased dual nationality, which would have provoked concern among 19th-century Americans. The United States has long recognized the general undesirability of dual allegiances. At the time of ratification, exclusive loyalty to the United States had long been a fundamental element of American citizenship, see also Part I, B, 2a. The view at the time was that a nation should as soon tolerate a man with two wives as a man with two countries. Letter from Bancroft to Lord Palmerston, see also Spiro, Dual Nationality and the Meaning of Citizenship. Opposition to dual nationality was especially strong after the Civil War. The country had just emerged from a civil war that cost the lives of over 600,000 men due to a treasonous denial of allegiance to the Union, the United States. Going forward, there would be no national citizenship absent a reasonable expectation of national allegiance. Lash, 101 Notre Dame Reverend an 1868 congressional report explained that if a person was a national of both his home country and the country of his birthplace, it could expose him to competing claims for compulsory military service, or could cause him to be summoned to fight for governments with which he has no connections, and against those with which his fortunes are indissolubly united. The intimate association of those who are claimed as subjects of foreign governments is such as to put in peril the rights or peace of all. Report of 1868. Accordingly, this court has long resisted reading the Citizenship Clause to inhibit the political branch's ability to address problems attendant on dual nationality. A rule that recognized the citizenship of children born to temporary visitors would have increased dual nationality. At the adoption of the Citizenship Clause, as today, most nations treated the children of their citizens born while temporarily abroad as citizens. See Spiro, 46 Emery. As a result, a child born in the United States of a temporary visitor would have immediately been a citizen of his home nation. If the court's interpretation were correct, the child would immediately also become a dual citizen. It is unlikely that the Reconstruction Congress constitutionalized such a rule. By contrast, the domicile requirement mitigated the problem of dual nationality. Each person had one and only one domicile, so tying citizenship to domicile avoided dual citizenship. See Inhabitants of Abington Field 147. Second, the domicile rule aligns national citizenship with the long-standing rule for state citizenship. Even after the court's decision today, Americans are citizens of only the state of their domicile, even if it is not the state of their birth. No one doubts that a child born to New Yorkers on vacation in Florida would be treated as domiciled in, and a citizen of, New York. For the same reason, one would think that a child born to Canadians on vacation in Florida should not be a citizen of the United States. The court, in other words, rejects and is bewildered by an approach to citizenship that is in fact the one we still know best. Third, the domicile rule would make the Citizenship Clause accord with America's treatment of its own domiciliaries abroad. America itself has long taken the position that children of American citizens born on temporary visits abroad are American citizens. Ludlam Cooley, Principles of Constitutional Law 243. Such children were long considered American citizens because their parents were domiciled in America. It is unclear why the same reasoning should not apply in the other direction. The court's alternative history is mistaken. The court's theory of the Citizenship Clause stands on three main pillars: Calvin's case, Lynch v. Clark, and Wong Kim Arkansas. None can justify the court's decision today. The first pillar of the court's theory is Calvin's case, a 418-year-old English common law decision. Calvin's case held that a child born in Scotland could hold land in England. According to the court, Sir Edward Coke's separate opinion in Calvin's case established the common law principle called jus soli, pursuant to which people owed perpetual feudal allegiance to the King of England if they were born within the dominions that he owned. Ante. This principle applied to all persons born on the land, not just those domiciled there. As the court tells it, the 1608 feudal principle as described by Coke was adopted as the law of citizenship in America and then incorporated by reference in the Citizenship Clause. Ante. The English principle was a rule of feudal servitude, not a rule of citizenship. In England there was no such thing as a citizen. The English principle instead determined a person's permanent feudal bondage to the king, which he could not unilaterally abandon. It was based on the notion that a man owed personal service to the lord of the soil, the same as his master owed it to the king, and it was born with the child and only ended in the grave, a relation of master and servant. Under the feudal system, every owner of lands held them in subjection to some superior or lord. Stone, Commentaries on the Laws of England. The lord would protect the vassal in the enjoyment of the territory granted him, while the vassal would be faithful to the lord, and defend him against all his enemies. See also Shuck and Smith, Citizenship Without Consent 12-18. The English feudal principle was not accepted by the American governments. Report of 1868. As Justice Alito explains, the principle that birth on the soil made a person perpetually bound to the king was premised on the theory that the king was anointed by God to rule the people like children. Post. John Adams famously wrote that the feudal theory meant that the common people were held together, in herds and clans, in a state of servile dependence on their lords, in a state of total ignorance of everything divine and human. Purse of John Adams 113. Americans emphatically rejected this theory. Post. They began their settlements, and formed their plan both of ecclesiastical and civil government, in direct opposition to the feudal system. They then dissolved all allegiance to the British Crown. Declaration of Independence paragraph 32. And they set up a new system of government in which the people were not regarded as servile dependents. Instead, the people were sovereign, and the government derived its legitimacy from them. Declaration of Independence paragraph 2. In this new system of government, feudalism had no place. See Rothbard, conceived in Liberty 532-573. The soil did not belong to the government, but to the people. And those who were born on it did not owe the government a lifetime of obeisance or servitude. The Reconstruction Congress expressly opposed the feudal principle that the court claims that it adopted. Contra, ante. As its Committee on Foreign Affairs saw the matter, there is nothing American in the oath of the land barons of England. Report of 1868. It described the English rules, claim of indefeasible allegiance and perpetual service, as the symbol of feudalism and force. Instead of the feudal principle, the Congressional Report explained that American law viewed people as taking on a new citizenship, as relevant here, when they changed their domicile. The same year that the Citizenship Clause was ratified, Congress passed a statute rejecting the feudal principle and explaining that it supported the right of all persons to expatriate and change their citizenship. -224 C. Spiro, 46 Emery. In fact, by the 1840s, even English law had evolved. England had moved on from the darkness of the Middle Ages, and, as the subjects of one kingdom began to migrate into and reside in other countries, had begun to attach a newfound importance to the law of domicile. Law of Domicile 14. Well before the Citizenship Clause, this court explained that the courts of England had decided that a person who removes to a foreign country, settles himself there, and engages in the trade of the country, furnishes, by these acts, such evidence of an intention permanently to reside there, as to stamp him with the national character of the state where he resides. A year after the Citizenship Clause, a renowned English case declared that a person's civil status, by virtue of which he has ascribed to him the character of a citizen of some particular country, is governed universally by one single principle, namely, that of domicile. The second pillar of the court's theory is Lynch v. Clark, a single state court case about citizenship, ante, from 1844. Thomas Lynch was a successful businessman in New York. When he died, he had no will and no children. Shortly after he died, his brother Bernard and his niece, through another brother, Julia, moved to New York from Ireland. The New York legislature then passed a special statute giving Lynch's property to Julia Lynch, subject only to the rights of the heirs at law of Thomas Lynch. The legislature then passed another special statute giving Lynch's property to Bernard Lynch, save for the claims of heirs of Thomas, and the existing rights of Julia Lynch. Lynch's business partner, John Clark, also claimed a right to property in his estate. Bernard then brought a bill in equity against both Julia and Clark. Julia cited the special statute giving her inheritance rights, but also argued that because she was born in the United States, she inherited all of Thomas's property and had other equitable entitlements. That argument turned on a state law bar on aliens inheriting real property, so Julia argued that she was not an alien. She argued, among other things, that she was not an alien because she was in fact domiciled in the United States at the time of her birth. Her father came here with an intention to remain, and thereby changed his domicile. The assistant vice-chancellor who was assigned the case held 6 days of argument, during which Julia Lynch's citizenship was not then made a very prominent point. After argument, the assistant vice-chancellor became so impressed with the importance of the question upon the citizenship of Julia Lynch that he asked for supplemental briefing on the issue. He then wrote a long opinion explaining his theory of American citizenship, which concluded that Julia Lynch was not an alien, but a citizen, and therefore entitled to inherit the property. Within a year, New York replaced the law that the assistant vice-chancellor interpreted with a new law that simply made aliens eligible to inherit property. The state shut down his court 2 years later. See Constable Art. 14. The offices of Chancellor, Vice-Chancellor, Assistant Vice-Chancellor, are abolished. The court's reverence for Lynch v. Clark is not commensurate with its importance. Lynch was not a precedent of this court, or any federal court, or any state appellate court, or even a court of law. Instead, it was decided by a New York assistant vice-chancellor, in a court of equities equivalent to a trial court. The assistant vice-chancellor, much like a magistrate judge, had the power to hear preliminary motions for the suppression of testimony and cases referred to him by the chancellor. The assistant vice-chancellor's opinion on Julia's citizenship was apparently not reviewed by any appellate court. See Mayton, Birthright Citizenship and the Civic Minimum, 22 Geo. Lynch also did not interpret the Citizenship Clause, a statute using the same language as the Citizenship Clause, or even a statute that remained in effect at the time of the Citizenship Clause. Instead, it interpreted a New York state law. The state law was replaced immediately after Lynch. C. N. 620 laws. If a single, expressly limited opinion from a specialized intermediate federal court does not establish a well-settled meaning that the court can assume Congress incorporated into a federal statute that uses the same language, Learning Resources Incorporated v. Trump, then a single state trial equity court decision interpreting a different law certainly does not do so. Lynch also lacked staying power. By the time of the Citizenship Clause, New York's higher courts had all but abrogated it. In Ludlam v. Ludlam, a New York appellate court held that the children of those traveling or sojourning abroad, though born in a foreign country, are not born under the allegiance, and are an exception to the rule which makes the place of birth the test of citizenship. That decision was affirmed by the New York Court of Appeals, which stated, by the law of nature alone, children follow the condition of their fathers, and enter into all their rights. The place of birth produces no change in this particular. Immigration J. Shortly thereafter, in Ludlam v. Ludlam, that state's highest court with all justices concurring spoke differently, saying that birthright citizenship depended on parentage rather than the boundaries of the place. When the New York legislature authorized a committee to codify its laws in 1860, the codification defined birthright citizens as all persons born in this state and domiciled within it, except the children of transient aliens and of alien public ministers and consuls. Political Code of New York. Then, during the 14th Amendment debates of the 39th Congress, Lynch went unmentioned. It was only during the Civil Rights Act debates that Lynch appeared, a single mention by a member who played no role in drafting the 14th Amendment. Lash, 101 Notre Dame Rev., footnote omitted, see Epstein, The Myth of Birthright Citizenship, at the time of the debates over the ratification of the 14th Amendment. Moreover, Lynch v. Clark appeared to play no role. So, while this court's opinion invokes Lynch 13 times in 26 pages, the entire Reconstruction Congress in the combined course of deliberations over the Civil Rights Act and the Citizenship Clause mentioned it only once. The third pillar of the court's theory is Wong Kim Arkansas. The question before the court today, whether the Citizenship Clause requires the President to recognize citizenship for the children of all lawful temporary visitors and illegal aliens, was not before the court in Wong Kim, Arkansas. Instead, the Wong Kim Ark court held that someone born in America to parents domiciled in the United States was a citizen. It rejected the government's argument that Wong's parents had to be citizens for him to be a citizen at birth. The Citizenship Order is fully consistent with this decision. Under the order, people like Wong remain citizens, and the government today nowhere urges the position that it took in Wong Kim, Arkansas. To the contrary, it invokes authorities that the government in Wong Kim Ark opposed. Compare brief for Petitioner 13-43, arguing for domicile rule, with T. 1895, number 904, arguing against domicile rule. The court nonetheless leans heavily on dicta from the majority opinion in Wong Kim Ark, which it takes to have established that Wong's domicile was irrelevant, and that he, a lifelong American, was indistinguishable from a person who had no meaningful ties to America. The court does not ordinarily put so much weight on past decisions' discussion of matters not before the court. It is a maxim not to be disregarded. This court has always admonished that general expressions, in every opinion, are to be taken in connection with the case in which those expressions are used. Thus, if they go beyond the case, they may be respected, but ought not to control the judgment in a subsequent suit when the very point is presented for decision. Instead, we emphasize, our opinions dispose of discrete cases and controversies, and they must be read with a careful eye to context. After all, the question actually before the court is investigated with care, and considered in its full extent, but other principles which may serve to illustrate it, are considered in their relation to the case decided, but their possible bearing on all other cases is seldom completely investigated. Trump vs. Cook, we review judgments, not statements in opinions, internal quotation marks and alterations omitted. Nor is Wong Kim Ark's dicta so clearly on the court's side. After a long discussion with many internally inconsistent statements, Wong Kim Ark's final statement of the rule comported more closely with the Citizenship Order's application to temporary visitors than with the court's view. The Wong Kim Ark Court concluded that the Citizenship Clause grants citizenship to all children here born of resident aliens, with the exceptions or qualifications of 1. Children of foreign sovereigns, 2. Children of foreign ministers, 3. Children born on foreign public ships, 4. Children of enemies within and during a hostile occupation of part of our territory, and 5. Children of members of the Indian tribes owing direct allegiance to their several tribes. It then reaffirmed that, the amendment, in clear words and manifest intent, includes the children born within the territory of the United States, of all other persons, of whatever race or color, domiciled within the United States. Wong Kim Ark also repeatedly emphasized that its holding was limited to domiciliaries. D3. It did so 7 times in the first paragraph and repeatedly after that. And, presciently, Wong Kim Ark itself invoked this court's oft-repeated reminder that general expressions that go beyond the case should not control the judgment in a subsequent suit when the very point is presented for decision. This is not quite no, 1,000 times no, but should have sufficed to dissuade the court from invoking the case with respect to the distinct legal and factual issues presented here. Learning resources, citation omitted. It is not surprising that Wong Kim Ark limited its holding to domiciliaries. The government in Wong Kim Ark stipulated that Wong was domiciled in the United States and argued that domicile was irrelevant at D3 brief for appellant. The court thus had little reason to consider what rule would apply to a temporary visitor. The court was hardly likely to upset the consensus that the Citizenship Clause required domicile in a case where the issue was irrelevant given Wong's domicile in this country. D. If Wong Kim Ark were so simple in establishing the court's rule as to temporary visitors, that meaning was seemingly lost on many. As a Department of Justice report confirmed in 1910, a dozen years after Wong Kim Ark, it has never been held, and it is very doubtful whether it will ever be held, that the mere act of birth of a child on American soil, to parents who are temporarily in the United States, operates to invest such child with all the rights of American citizenship. Spanish Treaty Claims Common, Final Report of William Wallace Brown, Assistant Attorney General. The Citizenship Clause's reference to jurisdiction does not mean that jurisdiction to which the bodily form of the child is subject from the moment of its birth, but instead that larger jurisdiction, which, though difficult to define, is well known and understood, the difference between the jurisdiction which is exercised over a visitor and that over one domiciled. In the years following Wong Kim Ark, the Citizenship Clause was generally understood as limited to children born of alien parents, not temporarily resident here, but permanently domiciled. Brannan 29. Nothing in Wong Kim Ark changed the consensus that children born in the United States to foreigners here on transient residence are not citizens, because by the law of nations they were not at the time of their birth subject to the jurisdiction of the United States. Paul, International Law. It would seem that the children of foreigners in transient residence are not citizens. Citizens must be domiciled. Guthrie, Lectures, permanently domiciled and residing here. Westlake, International Law. When a father is, in the Union for a transient purpose, his children, born within it have his nationality. Black, Handbook of American Constitutional Law. No citizenship for child of a stranger or traveler passing through the country, or temporarily residing here. 1 Bellet, Leading Cases on International Law. Children, of foreigners in transient residence, are excluded from citizenship, even though born within the United States. As for the remainder of the court's reasoning, much of it is self-defeating. To begin, the court invokes Frederick Douglass's statement that, the Constitution knows all the human inhabitants of this country as, the people. Ante. But, temporary visitors are not, inhabitants. To be an inhabitant, a person must be domiciled. See Cooley, Constitutional Limitations 661, one is an inhabitant, resident, or citizen at the place where he has his domicile. Crawford v. Wilson, inhabitant is defined to be one who has his domicile in a place, as distinguished from an occasional lodger or visitor. Sears v. Boston, the domicile, or the fact of being an inhabitant. Littlefield v. Inhabitants of Brooks, where he was an inhabitant, where he had a domicile. And, Frederick Douglass himself argued that blacks were citizens because they were not comparable to temporary visitors, they were not aliens, they were not exiles, and they were not strangers. Instead, they were Americans, he said, who, unlike temporary visitors, owe equal allegiance to the same government. Likewise, the court invokes Attorney General Bates's statement that persons born here were, prima facie, citizens. But, the court does not seem to be aware that this phrase corresponds to the rule of domicile that the court rejects. See President and Fellows of Harvard College, the place of birth is, prima facie evidence of domicile. See also, e.g. if a person's parents were domiciled abroad, then the prima facie case was overcome. Beyond these statements, the court mainly emphasizes that the children of temporary visitors owed a partial allegiance to and were owed partial protection from the sovereign. Ante. That, undisputed, fact does not demonstrate that the children of these visitors were citizens. To the contrary, Senator Trumbull explained that the Civil Rights Act was written to avoid this very misunderstanding. The act said, not subject to any foreign power, instead of owing allegiance to the United States precisely because temporary visitors owed a partial allegiance to the United States, and he did not want anyone to mistakenly conclude that the act included the children of temporary visitors. At 572. The language chosen thus excluded temporary sojourners, who continued to owe allegiance to their native country. Finally, the court relies on general statements without recognizing that those statements are also compatible with my view of the Citizenship Clause. The Citizenship Clause indeed followed the pre-existing law, e.g. ante, but the pre-existing law was based on domicile. Children born here to foreign parents indeed were generally citizens, see e.g. ante, but that is because they were generally domiciled here, and citizenship did indeed almost always follow birthplace, e.g. ante, but that is because birthplace almost always followed domicile. The court's responses to my view also undermine its own. The court criticizes my view for depending on the parent's status, not the child's. Ante. But, the court's view depends on the parent's status, too. The court, for example, excludes from citizenship the children of representatives of foreign sovereigns or enemy invaders. Ante. Unless newborn babies are serving as international diplomats, the court's account thus turns on parent status. Along the same lines, the court asks why words appearing frequently in the executive order mother, father, lawful, temporary, are absent from the clause. Ante. But, again, if that is a problem, then it is one for the court's theory as well. After all, the court's exceptions, for foreign representatives, Indians, and invading enemies, do not appear in the clause either. Finally, the court suggests that domicile is a difficult concept to apply. But domicile is, of course, a concept widely used in both federal and state courts for jurisdiction and conflict of laws purposes, and its meaning is generally uncontroverted. And the court's concept poses its own administrability questions. The court never explains, for example, what happens when a child is born to a citizen and a diplomat or to a citizen and a member of an invading army. The court also suggests that my interpretation of the Citizenship Clause is not consistent with the Civil Rights Act's not subject to any foreign power requirement because a foreign nation can purport to exercise power over its original citizens even after they establish a domicile here. Ante. But, the court's interpretation of the Citizenship Clause does not even attempt to be consistent with the Civil Rights Act's requirement, since the children of temporary visitors are clearly subject to the foreign power of their homeland. Regardless, the court is wrong about domiciliaries remaining subject to the foreign power of their country of birth. Although their nation of origin might purport to exercise jurisdiction over them, the United States would not have had to recognize that authority as lawful once those persons were domiciled here. The court ultimately denigrates the evidence in support of my position as scant. Ante. I see it differently. The court cites little evidence from the Reconstruction Congress that gave us the Citizenship Clause. And its other 19th-century evidence is slim in comparison. As for the evidence in support of my position, it is substantial. Representative Bingham, the architect of the 14th Amendment, believed that the Citizenship Clause would not apply to the children of temporary visitors. Senator Trumbull, a principal champion of the amendment, agreed. Jacob Howard, who introduced the Citizenship Clause, agreed. Congressman after congressman during the legislative debates agreed. Congress in 1870 agreed. President Grant's Attorney General agreed. President Grant's Attorney General before that agreed. The Supreme Court in 1873 agreed. State legislatures agreed. Executive branch decision-makers over the course of multiple decades agreed. Justice Miller agreed. Thomas Cooley agreed. A battery of other eminent scholars agreed. And the great Justice John Marshall Harlan, on 3 separate occasions, agreed. Once again, I am quite comfortable in the company I keep. Number 1. Before concluding, I briefly address plaintiff's argument that even if the Citizenship Order has at least some lawful applications consistent with the Citizenship Clause, it is not consistent with the statutory citizenship provision in force today. The court gives no independent import to the statutory citizenship provision, and I would not, either. From 1866 until 1940, the statutory citizenship provision required that a person claiming citizenship based on birth in the United States be not subject to any foreign power. C. That language from the Civil Rights Act, like the language of the Citizenship Clause, required that a person claiming citizenship have a domicile in the United States. So, both the statute and the Constitution required domicile until at least 1940. The Nationality Act of 1940 codified the existing law by enacting the Citizenship Clause's text. By the early 1930s, the American law on nationality was expressed in a large number of provisions scattered throughout the statute books. President Roosevelt designated a committee to review existing nationality laws and, as relevant here, to codify those laws into one comprehensive nationality law. Revision and Codification of the Nationality Laws of the United States, Exec. As a result of that process, Congress enacted the Nationality Act in 1940. C. Perez. The Nationality Act was the first attempt ever made since the founding of our republic to codify and unify all the laws of the United States relating to the important subjects of nationality and naturalization. Knight, Nationality Act of 1940, 26 J. 938. A codification of existing law does not change the law unless it does so clearly. When legislatures consolidate their statutes at large into a code, they often revise the wording of the prior statute to provide for consistency of expression. But that revision does not result from legislative reconsideration of the substance of codified statutes. The same is true for legislative restyling exercises short of codification. Such new language does not amend prior enactments unless it does so clearly. See also, e.g. The Nationality Act's citizenship provision codified the Civil Rights Acts not subject to any foreign power requirement and the Citizenship Clauses subject to the jurisdiction requirement. It did so by borrowing language from the Citizenship Clause, which granted citizenship to all persons born in the United States and subject to the jurisdiction thereof. By using language that tracked the Citizenship Clause, Congress did not clearly change the law. It would be surprising to discover that Congress departed from the constitutional standard by enacting the exact constitutional language. Poly 301, 313. The 14th Amendment was enacted in the wake of the Civil War, with the one pervading purpose of securing equal citizenship for the freed slaves. It was enacted, as Justice Harlan wrote, to secure to a race recently emancipated the civil rights that other citizens enjoyed. This court has time and again denied Americans that promise. Shortly after the amendment was ratified, this court deprived black citizens of the right to peaceably assemble and to keep and bear arms. A little later, in Plessy, the court upheld the subjugation of black citizens in the form of state-coerced racial segregation. When it had an opportunity to correct that profound error, it did so narrowly. It then used that very decision to justify busing American children to different schools based on their race. And, until recently, this court continued to selectively enforce our colorblind Constitution, including by allowing state-coerced racial discrimination in public education, e.g. Grutter v. Bollinger, and compelling states to draw political districts on the basis of race, e.g. Meanwhile, the court has repurposed the 14th Amendment to protect its own set of preferred rights that the Reconstruction Congress never contemplated and that cannot find support in its text. Today, the court does so again by recognizing a constitutional right to citizenship for the children of all foreign-birth tourists and illegal aliens. I am not sure that today's opinion will stand the test of time. The Citizenship Clause added greatly to the dignity and glory of American citizenship. Today's opinion devalues that citizenship. I respectfully dissent.